All right. Here, Court of Appeals of the State of Michigan is now in session. The Honorable Mark T. Boonstra, the Honorable Brock A. Schwartzel, and presiding the Honorable Michael F. Godola. All persons having business hearing draw near, give attention, they shall be heard. God save the United States, State of Michigan, the Honorable Court, please be seated.
Good morning. On behalf of my colleagues, Judges Boonstra and Schwartzel, welcome to the Michigan Court of Appeals. This is panel 6 in Lansing. I usually say this is day 1 of our case call, but it's only one day this month. So, and this is it. And so this is the 10 a.m. Portion of our case call. I'll give my usual advice to the lawyers. We've read your briefs. We've had reports from our staff on all the cases, so we're very well familiar with the facts and your arguments that you've put forth to us. So we would ask that you not belabor the facts in your argument, just cut right to the most salient legal issues and tell us as succinctly as you can why you should prevail in your appeal today. I don't think we have any cases involving protected persons. Doesn't look that way. So I don't need to talk about the use of.
We do have a couple cases involving minors.
Do we?
Yeah.
Okay, all right. I'm looking at the captions. If there are cases involving minors, maybe they're not in the captions. Avoid the use of proper names, just initials only. These proceedings will be uploaded to YouTube within the next 24 hours. So with that, I think I can call our first case of the day. That's item number 1, docket number 358946, People of the State of Michigan versus Stephen J. McKell Bryson.
Good morning, Your Honors. Mike Middlestat on behalf of Mr. Bryson. I don't think I'll need it, but I'll reserve 5 minutes of my time for rebuttal. As you know, this is a home invasion case, and the state's case really was a 3-legged stool. One leg was a picture of Mr. Bryson taken weeks or months after the break-in, showing him with a gun, possibly one of the stolen guns, which is not particularly compelling with regard to the home invasion, because all it shows really is that he had access to the stolen property afterwards. The other 2 legs were the 2 former co-defendants of Mr. Bryson, Leonard Wilson and his daughter, Caitlin Wilson. Now, to torture the metaphor a little bit more, the jury knew that those 2 legs were a bit wobbly, right? They had a little bit there was reasons to kind of doubt their credibility. They both had been paid, and I'm using that term not
monetarily
necessarily. Yeah. They had received a benefit for testifying. So that was out there for sure. Caitlin Wilson also had given some at least 2 inconsistent statements and had another motive to fabricate because there was a breakup between her and Mr. Bryson. So her testimony, her credibility hinged upon Leonard Wilson's testimony because it corroborated her in many respects. The problem is the jury didn't hear just how wobbly the leg of Leonard Wilson was, because of 2 due process violations. One was that the prosecution didn't correct substantially misleading testimony about the terms and the status of his plea agreement. And the prosecution did not disclose impeachment evidence in the form of a crime of dishonesty that Mr. Wilson had suffered. Now, just on the first issue, the trial court ruled that this was not substantially misleading. And I think the court's wrong, and you should reverse the court on that, because a conviction is far different. The conviction and entry of a plea is far different from dismissal without prejudice, with a wink and a nod that we're going to do something for you later on. 6-month jail sentence is far different from spending 6 months in pretrial detention on not just this case, but 2 other cases. And those are substantially different things. Now,
on the dismissal without prejudice, wasn't there some testimony in a subsequent hearing that the prosecutor had planned to refile at some point in the future, but it's, I think, unequivocal that those charges were never filed. Is that fair?
She forgot.
Okay.
Forgot to refile. So, and then Mr. Wilson died. So now, how else is it material? It's material because the jury was led to believe that there was already a conviction and that Mr. Wilson had served a sentence. So the only thing left was the final installment in that deal, which was to testify. So they had the impression that he was doing it because it was the right thing to do, or at least that they could have drawn that in.
But he'd already been convicted and served his time
Yes.
in jail.
Yeah,
So
exactly.
the jurors may have thought, well, this man has no reason to fabricate because he's
Precisely.
already received the benefit of the bargain.
Precisely, Judge, precisely. What in reality was, and I think the prosecution agreed with this, is that he still had these charges hanging over his head. They were felony charges. He was a habitual offender. There was a firearm enhancement. That's markedly different. And the prosecutor had the say in whether he complied with, the plea agreement by towing the line with regard to the testimony. Had they known that, that's a far bigger impetus, a far bigger motive to slant his testimony against Mr. Bryson.
Now, the testimony may have been substantially misleading at best from the prosecution's point of view. I say at best.
Mhm,
I think it was more than that. But then I think you might have left out the more important part, which was the jury instructions.
Yeah.
Where the trial judge sort of removed any doubt.
Yeah.
And the prosecutor sat silently at counsel table and did nothing to correct the clearly false jury statement made when the court was delivering the jury instructions, right?
Yeah.
So can you
Yeah, you
enlighten us as to
you
what
kind
was
of
said?
took the wind out of my sails.
Okay, you sounded,
You were building.
you kind of stopped, so.
It was a dramatic pause there.
Right.
So yeah, I mean, we presume that the jury follows the court's instruction. I know that there's an argument that she kind of equivocated a little bit on whether it was an offer or whether it was a plea or entry of a plea and a conviction, but she never corrected herself. She said it's a conviction and it's a 6-month sentence. So that just reinforced it. Now, I know that there's sort of an argument that the defense was somehow responsible for this because he elicited the misleading testimony on cross, and then he signed off on the jury instruction. Well, he had no reason to believe that this prosecutor wouldn't abide by her ethical duties as an officer of the court and as a sister counsel. So he was entitled to rely on that, and he was entitled to, assume that the witness had told the truth about the terms of the plea agreement. Now, again, you're right, Judge. The court told the jury that this was a situation. The jury did not have any reason to doubt the court. And so when you get this, and again, this is the threat of a serious charge hanging over his head at the time of his testimony, as opposed to this is just the final wave there. And I think that goes to both how much the jury was misled, and it goes to materiality. Now, you're going to ask what's the big deal? Caitlin Wilson also testified that there was a break-in and that Mr. Bryson was involved. Well, as I started out saying, Caitlin Wilson had credibility problems. And I go back to reminding the court, and I reminded the court below, that this is a due process violation, so the prosecution has the burden of proving the error harmless beyond a reasonable doubt. The prosecution didn't attempt to do that at the hearing, and they really haven't done it in their brief here. They've given a truncated analysis of why it's harmless, but really that analysis is a sufficiency argument. Appellate review for harmless error is not simply a matter of blocking out the bad stuff from the transcripts and seeing what's left. And if what's left is enough, it's harmless. No, the appellate review for harmlessness is to determine how the error would have affected the jury's view of the evidence. And then I go back, and again, filtered through the lens of it's their burden of proof. So again, I go back to the three-legged stool analogy. Caitlin Wilson had significant credibility problems. Her credibility hinged on the corroboration from her father. And once you show that her father not only fudged about the benefit of the plea bargain, but he actually looked at the jury and told them that he'd been convicted. I want to just stop here and cite a case that came out from the U.S. Supreme Court since the briefing in this case. The case is Glossop versus Oklahoma, 604 U.S. 222. They do a good job of emphasizing the significance of a witness admitting or at least being exposed at trial of lying, right? If the jury sees that this person not only had a motive to slant his testimony, but that he looked the jury in the eye and said, this is the case, and that's not true, that is significantly impeachment. That's different from just having this witness have a motive to fabricate. This is proof that this witness has lied under oath. So, you know, from that standpoint, I think his credibility was significantly undercut from that standpoint. And again, he's supporting Caitlin Wilson's testimony. He's supporting her credibility, and she had plenty of credibility problems.
Well, among which would be, and correct me if I'm wrong, she didn't implicate your client in this crime until after her father bonded her out of jail. Is that?
Yeah, I think, and they broke up.
Mhm.
And they broke up. So, I mean, the jury could infer that this was a messy breakup and that there was some, you know, vitriol there. So, and she got a sweetheart deal. The jury knew that she got the case to charges completely dismissed. So, I mean, they knew what they should have known about her father, which is that she had no exposure whatsoever at that point.
Really, the only other piece of evidence, aside from the two, the father-daughter.
The Wilson
and
combo, yeah.
Leonard and Caitlin, their testimony was the photo you referenced.
Was
at
the photo.
outset.
And the photo shows him with a gun that
Yeah.
is similar. And it's months after Mr. Bryson lived with the two co-defendants. So he had access to the stolen goods. So that's not, it's, you know, supportive, but it's not particularly compelling there. Now, I want to add in the Brady violation. And this is a crime of dishonesty. So not only do we have the jury learning that he lied to them, but the jury would have learned that he lied in the past, very recently. He lied, you know, he's a person who, when it benefits him, he will lie. And I think any doubt about his credibility would be significantly erased on that point, at that point, because he, you know, he's just viewed as a complete liar. And that's why I go back to the Glossop case. And the Glossop case the court does a good job of saying, look, this is significant. Had the prosecutor done the right thing and corrected his testimony, the jury would have said, hey, what's the deal? This guy lied to us. So with that being said, unless the court has any questions, I will reserve the remainder of my time for rebuttal.
Okay,
Thank you.
Good morning, may it please the court. Assistant Attorney General Brent Morton on behalf of Oscoda County. Well, I've got a little uphill battle, it sounds like. I want you to focus on a couple of things when you're looking on whether or not this is substantially material. And with all due respect to opposing counsel, I think there's some suggestions that aren't supported by the record. One suggestion was that these charges against Leonard were dismissed with a wink and a nod, or that somehow the prosecutor failed their ethical duty to reissue the charges timely. There is no suggestion in the record, nor at the post-conviction hearing, that anything inappropriate was done here. It was post-COVID. They missed reissuing the charges. When it was discovered, Mr. Wilson had passed away. No
I
point.
agree with you. So
Okay, thank you. I
just
just,
the primary person you probably think you have an uphill battle with. I agree with you.
But the question remains, how did the misimpression given to the jury
Right.
affect their ability to evaluate his credibility?
well, I think that what I want you to focus on is the impression that was given and what actually should have been given. Not the fact that he didn't have charges against him. The jury should have been told he does not currently have charges against him, but they will be reissued as a felony and he will plead to a misdemeanor. That was the deal. I mean, and that's why the Brady violation was found with regards to.
That was the deal, but that's not how things shook out. I mean, it's easy to say that was the deal at the time, but when you look, none of that happened.
But had he lived, then it would have happened.
We don't
How-
know that.
Yeah, we don't, I mean, let me ask you this, what was the timing in terms of his passing and when he testified in this trial? how many months or years?
I do not know.
So when you say, well, if he had lived, then he would have been recharged and he would have pled to a misdemeanor. You don't really know that.
Well, my recollection of the conviction hearing was that the prosecutor indicated that when they went to recharge it, they discovered he'd passed away. And so they did not recharge it.
Okay.
And that was the deal all along, and that Wilson knew that was the deal, that he was going to have to plead to misdemeanors
What
and be
about-
subject to possibly additional jail time.
What about, the beginning of Leonard's testimony was a little ambiguous, and so I could see why the prosecutor might not have felt a need to correct it. But on cross-examination, Leonard clearly said, yeah, I pled to a misdemeanor. And then the jury instructions clearly indicated that he had pled guilty to a misdemeanor. Why wasn't it incumbent upon the prosecutor at those 2 points to stand up and say, Your Honor, we need to correct the record, or we need to do something because that's not accurate?
It should have been corrected, absolutely. But we're all human, errors get made, and, as it says, defendants are entitled to is not entitled to a perfect trial because there are no perfect trials. Yeah, I wish that had been corrected, then I wouldn't be here trying to convince you that it wasn't substantially material. But unfortunately, that was missed. I think it was unintentional. I don't think that there was any strategic reason for not getting the jury instruction correct.
So the jury thought he had served his time, been convicted, and presumably then had no reason to think he had a reason to lie when he was on the stand, right? But if he still has that hanging out over his head that they're gonna recharge him, doesn't that give them reason to believe that he has more of a reason to testify for the prosecution, even if it might not be true?
See, I don't see it that way. The jury doesn't know that the charges can be, that can be withdrawn and the charges can be reissued if he'd not followed through on the agreement.
But none of that could have happened under what the jury was led to believe, because
Right, they weren't instructed that.
they
there
believed
was
he'd
any-
already been convicted and served his time.
So,
So, as far as they were concerned, none of what you just put forth could have happened. I understand why the prosecutor did what she did. And I think there's, good reason for that practice, but first, you need to follow through on it. And second, you need to correct the record when it's misstated in the testimony. And when the court makes just completely misleads the jury in the final instructions.
well, I think the jury was told that he got misdemeanors out of a felony and he only did 6 months jail.
I mean, I think we
And
agree it
that's
was an
what
error.
they-
You just conceded it was an error. So why is it not, substantive?
Because it's unlikely to affect the outcome in our position.
Why?
Because they knew substantially what the deal was. He got a deal for his testimony, and I think people realize that in the criminal justice system, people get deals, and that's why there was an accomplice instruction to say, you be critical of this testimony of both Leonard and his daughter, because they're accomplices that are getting a deal. And so the deal was communicated to the jury substantially similar to what the actual deal was that they agreed on and what everybody believed they were functioning under.
But I think to opposing counsel's point, if the record had been corrected, the jury would have seen that at least in one instance, Leonard absolutely lied to them because he said, yes, I have been convicted of a misdemeanor involved in this. So they would have at least had one data point of him outright lying to the jury. Then if the Brady violation hadn't occurred and the jury had also learned that he had been convicted of another instance involving dishonesty, how would that not have really undermined the credibility almost to zero of Leonard's testimony in the eyes of the jury?
Well, I think that it would have given the prosecutor an opportunity to point out that when he said he was convicted, he was agreeing with defense counsel. And so there, I mean, it's an inaccurate statement, but it's not, it wasn't on direct examination.
Yeah, but I
Um,
mean, you know, and I saw the argument about, well, defense counsel invited this. I mean, defense counsel had no reason to suspect, or, you know, this wasn't an area that defense counsel made a strategic choice of whether to get into or not. Defense counsel had to get into this issue, and Leonard just outright lied.
He's asked by defense counsel, you did in fact plead to a misdemeanor, correct? Answer, yes. I took the same plea that other people were offered. That's a lie. Isn't it? At the time he gave that testimony, that was a lie.
Yes.
So again, to go back to my question a few moments ago, you take that one lie, and then if defense counsel had been made aware of his recent conviction involving dishonesty, if the jury had been made aware of that, don't you think that that would have seriously undermined Leonard's credibility in the minds of a reasonable juror?
I think it could.
Okay.
I think, but I think the deal was substantially the same as what they indicated they were going to do. And but for Leonard's death, they would have followed through on that.
So if we analyze this and say, Leonard's not maybe the most credible witness we've ever seen, what other evidence of guilt was there? I know opposing counsel doesn't want us to do that, but if we look at this as kind of a quasi-sufficiency question, what other evidence of guilt was there that would support?
We have the daughter's testimony, we have the gun picture.
Anything else, Mr. Morton?
No, thank you very much.
No, it's been helpful.
Was it
Thank you.
ever established that the gun in the picture was one of the guns taken, or was it just a similar gun?
It was a similar firearm. And I don't, as my recollection is in the picture, you could not see anything distinctive about it being a service firearm. Thank you.
Middlestat.
Thank you, Your Honor. I want to go to opposing counsel's first point, and that's kind of like there was this mens rea requirement, or this wasn't intentional. The standard isn't intentional misleading or intentional failure to correct. The standard is knows or should have known. It's more of a recklessness or and I think the prosecutor basically acknowledged that she was negligent. She dropped the ball on that. Point number two to that point is the trial in this case was in August of 21. Leonard Wilson died in June of 22. And the prosecutor,
Nearly a year.
and the prosecutor admitted at the evidentiary hearing that she learned of his death through the pleadings in this case.
That's what I.
So she just dropped the ball. She just dropped the ball. And again,
There was no suggestion that she had prepared papers to refile against Mr. Leonard,
Yeah.
correct?
Yeah.
Okay.
no, there was no memos to the file. There was no emails to the prosecutor or to the defense counsel. There was nothing put on the record. There was nothing really to show that this was in the works at the time he took the stand there. So, I think that's probably, again, unless the court has any concerns about the interplay between Leonard and his daughter, Caitlin, and, just reminding the court that it's their burden to prove it's harmless and that you have to look and see how much Leonard's testimony supported Caitlin's, and that without that other leg of the stool, Caitlin's becomes a lot more wobbly as well. Thank you.
Thank you. All right, thank you, both. The cases submitted, your arguments were very helpful. We appreciate it. And Mr. Morton, you can stay right there. Because next item is number 2, docket number 364-897, People of the State of Michigan versus John Derek Mall.
Good morning, Your Honors. Henry Schneider from the State Appellate Defender Office here on behalf of Mr. John Mull. And I do have some brief remarks. I intend to rest on my brief with respect to the sentencing issue, but I'm happy to accept your direction at any point.
Sure.
That being said, the trial that John Mull got is not what a fair trial is supposed to look like. Trial counsel's errors combined with the prosecutor's errors combined with the significant Brady violation in this case deprived him of a fair trial. The record as it exists is replete with indications that trial counsel is not up to the task of effectively representing Mr. Mall. He didn't file a witness list or investigate witnesses. He did not file timely or complete pretrial motions, particularly with respect to other acts witnesses. He did not object to inadmissible expert testimony. He did not request necessary jury instructions, and he did not object to the prosecutor's improper arguments in closing. But most damningly for Mr. Mall, trial counsel did not investigate cell phone communications, particularly texts between John and Melissa, the complaining witness in this case. As a result, the jury was told that 286 text messages represented the entirety of John and Melissa's conversations via text over a 1-month period between the date John was kicked out of Melissa's house and the date of the alleged incident.
Were they expressly told that this is the entirety of the text messages, or is that simply what was presented as an exhibit, which happened to be incomplete?
It was presented as an exhibit. My understanding is that it was presented as the complete record of their text in that time frame. And the prosecutor suggests that they turned everything over to trial counsel initially. But if that's the case, it doesn't explain why that exhibit looked the way it did at trial. And as indicated in Mike Waldo's affidavit, he previously represented Mr. Mall as he was at Sato, no longer, but as indicated in his affidavit, it took months, a motion to compel, a hearing on that motion, and multiple visits to Michigan State Police to get his hands on all those texts. So at the very least, Mr. Mall needs an evidentiary hearing to determine exactly who had those text messages and when, and to further develop the materiality of those texts that were not provided. And while these issues that I outlined are significant on their own, I'd really like the court to consider the interplay between some of these issues, particularly with the Brady violation. His failure to investigate those hamstrung him at trial in several respects. For one, he didn't have everything he needed to effectively cross-examine Melissa. For another, the extra texts would have made the need for a mistake of fact during instruction more obvious.
Clear, these are the text messages between the time he moved out of the residence and the date of the incident.
That's correct. And I believe shortly after the incident as well, a few hours at least.
Right.
But they offered a much more complete picture of John and Melissa's relationship and the cycles they often went through and the communication style that they engaged in.
That's a good way of putting it.
Yes, they would frequently argue, engage in fairly heated arguments over text, but they would often lead to sexting and sexual conversations, which would often lead to consensual sex. In fact, the night before the alleged incident, they engaged in consensual sex following a series of texts as I described. But two other issues that really dovetailed and interplayed in a way which harmed John Mall are the other act's witnesses and the expert testimony in this case. The other act's witnesses testified that really gave testimony indicating that John had been a physically abusive partner in the past. And the expert testimony in this case was that 80 to 95% of people who are in domestic violence relationships also suffer sexual assault at some point. And so because trial counsel didn't object to any of this,
Your client wasn't charged with domestic violence, right?
That's correct.
CSC 1.
CSC
Home
1,
invasion
larceny.
and larceny.
And
So I have struggled to understand how any of that testimony about the physical abuse and the prior relationships was in any way relevant to this case.
correct. And had trial counsel abided by the filing schedule and filed complete briefed motions on that subject, even if those other ex-witnesses weren't excluded altogether, their testimony should have been significantly narrowed and limited. But as it stands, the other ex-witnesses' testimony is filled with allegations of physical abuse primarily. None of them alleged sexual assault or abuse, but the sheer volume of that testimony, combined with the expert's statistical statement, combined to tilt the playing field against Mr. Mall such that he didn't have a fair trial.
And does the same argument carry over to the expert testimony then, in
Similarly.
terms of its relevance?
Yes, and I draw the comparison to Thorpe in this case where, yes, Thorpe spoke more directly to credibility, but in both cases, what you had was an expert citing unreliable statistics based on data the jury had no access to, and ultimately bolstering the complaining witness's credibility. And in sum, John, he didn't get a fair trial. These errors did not occur in a vacuum. They interplayed with one another and interacted with one another in ways that compounded. I would like to reserve 5 minutes for rebuttal. I should have done that at the start. But if you have no other questions, I'll have a seat.
Any questions? No. All right. Thank you. You have time, plenty of time for rebuttal. Mr. Morton.
Good morning again.
Good
Assistant Attorney General Brent Morton on behalf of Shiawassee County. The first and foremost thing I want you to focus on in this case is remember that the defendant testified in this case. He testified that the victim in this case invited him over to have sex, and I won't repeat what his testimony was, but it's fairly graphic and it's in the transcript on, I think, page 101 to 102, and very explicit about her inviting him over for sex. So a mistake instruction is inappropriate because there was no mistake. That wasn't the defense. The defense was consent. And that's why the defense attorney worked with the prosecutor or worked against the prosecutor and agreed to a consent instruction that the jury gave.
Could there be a mistake of fact about consent? Could his argument have been, I thought she consented, but, to allow me into the house because I had a key and I used to come into the house all the time, but, maybe the wires got crossed in the text going back. I mean, I'm just asking whether the mistake of fact could have been about a factual question about consent.
In a different case with different testimony, yes, but not in this testimony.
Why?
The defendant testified, her exact words were, "Come over and F my brains out and cuddle."
That's what he said, she said.
That's what he testified to, that she said, and that's why he said, I came over and did what I did. So I don't think that there's any mistake there. If different testimony, different case, yeah.
Hard to cross those wires.
Now, with regard to the Brady violation, we have all these text messages, 5,000 text messages, and we've been given nothing that suggests that it would have been helpful with regard to that question. I think the opposing counsel and Mr. Mall want us just to be overwhelmed by 5,000 text messages that were allegedly denied to their attorney. But yet all this time has passed and we don't have anything from defense saying this would have made a difference. Look at this text message. What the text messages showed were after this 50-second phone call, he continued to try to get permission or get an invitation to come over and have sex, which is inconsistent with someone who consents during a telephone call. If she had consented, if she had really said this, what he said, she said, then he would have been in the car on his way over to her house. He would not have continued to text back and forth. So there's a lot of text messages. This phone dump, it got lost. Our position is it was turned over. Their position is it wasn't. Who knows? We don't have any record on that because there was nothing post-conviction done in the trial court. The reality is, there's been no offer of proof that any single text message would have made a difference. And it's on their burden to do that. With regard to the other ex testimony, you asked, well, why is this DV testimony relevant of the other victims? Well, it's relevant to show the relationship and the power control situations in domestic violence relationships. And that goes towards consent.
What does that have to do with CSC one, and why is consent relevant at all in this case? This was charged under MCL 750.520B1C. And CSC one, under that subsection of the statute, has two elements: sexual penetration, number one; number two, that occurs under circumstances involving the commission of another felony. That's it. So I don't think anyone is, I mean, I can ask your opposing counsel on its rebuttal whether anyone's disputing, but I don't think it was disputed at trial that there was sexual penetration in this case. So the issue of consent, it seems to me, is completely irrelevant, even though the jury was instructed that that was an alternative theory in this case. I think improperly, because as I indicated, sexual penetration, the alleged victim, purported victim in this case, says that there was sexual penetration. I don't think the defendant in this case denies that there was sexual penetration. So the case then boils down to whether or not there was another felony committed, that being either the home invasion or the larceny of the cell phone. So, and those are disputed issues. He claims he had consent to at least enter the home, as he had the previous night. And then he claims, maybe somewhat unbelievably, that he just gathered up the cell phone mistakenly, but didn't intend to take it or steal it. So there's at least a dispute over those things. So this causes me to ask why we spent all this time contesting consent versus no consent.
Well, consent was his defense. And if she had consented to him coming over, then there'd been no home invasion. So I think it
Right,
goes
but
directly to.
the consent would be to enter the home. That'd be the question of consent, whether she had consented to him entering the home versus what I think a lot of the trial focused on, which was the sexual activity, consented or not. She said no, he said yes. But to Judge Godola's point, there's really no question that sex occurred here. That's element one, check. And then you go to element two, which is, was there another felony? Which is, again, is the home invasion or the larceny. So even a defense of consent would be, well, she consented to me coming into the house. I don't think, frankly, he has a defense of consent with regard to the phone. So why was there so much focus on whether she consented to sexual activity when that really wasn't an element that was at play here?
Well, I think in a practical sense for jurors, if I'm consenting to have someone come over for sex, then they're going to come into my house. They're not going to wait outside, So I think the consent kind of covers both acts. And it's the defense to the home invasion. Hey, she wanted me to come over. I came over at her invitation.
I'm inviting you to correct me if I'm wrong, because I'm not 100% certain I am right about this section of the statute, but this is my reading of it. That it requires this particular subsection: sexual penetration occurring under circumstances involving the commission of another felony. So just as a hypothetical, not too dissimilar from what happened here, if an individual, let's say a male individual, visits his girlfriend in her home and they have consensual sex, and immediately thereafter he sees $100 bill sitting on top of the dresser, he takes it and runs out of the house, that individual could be charged with CSC 1 under this subsection of the statute. So, consent or no consent, it doesn't, consensual sex under that scenario, where there's another felony committed, I don't think that's the scenario that the drafters of the statute contemplated. I think they're probably contemplating like a kidnapping type of situation where, you know, an individual is kidnapped or a gun is held to their head. And then, you know, sex occurs at that point. So you have sexual penetration and another felony, that's CSC 1. Not what happened in this case, not the hypothetical that I gave you, but that's the way the statute's drafted, which it seems to me makes, if I'm right, consent irrelevant.
I have not, I'm gonna be no help, because I'm gonna decline to opine. I have lots of thoughts, but
It
I
wasn't
haven't,
raised.
I haven't read through the statute and I don't want to talk off my sleeve.
Right, okay, that's fine. Fair enough.
I think with regard to Ms. Rosen's testimony, you know, she was asked about her, you know, she needs to talk about what her experience is. She talked about how many people she had treated. And then she was also questioned about the connection between sexual abuse and domestic violence relationships. And she answered that. Those are not, should not be pushed together into any way to suggest that there's some sort of percentage that can be found. She was not vouching for the testimony of the victim. She made it very clear, I don't know any of the facts of this case. And she made it very clear. And there was a jury instruction, the jurors were to decide whether or not there was a domestic violence relationship.
I want
So
to,
I think those protected the defendant.
I want to go back. I know you said you're going to be no help, but maybe we can get somewhere. Was there any identification in the jury instructions or just the way that the trial unfolded about what the parties or the court thought the commission of any other felony meant? Was there any suggestion that any other felony was a home invasion or a larceny, or was this, an assault during the sexual activity that somehow satisfied the CSC 1 definition here? I mean, was there any, did the trial judge instruct the jury indicating that if you find that there was a larceny, which would be a felony, and that occurred, right around the time that the sexual activity took place, that would be guilty on CSC 1? Was there any framing of it that way? Do you recall?
I don't recall from my reading of the
Okay.
instructions. I don't remember how they're worded.
Because it is an oddly worded statute, at least in this particular respect.
I'm happy to answer any questions or any additional questions.
All right.
Thank you
very
so much.
Appreciate it. Counsel.
Just very briefly, I'd like to respond to a couple points. First, with respect to John's testimony at trial about receiving an explicit invitation to come over that night, part of trial counsel's job when preparing for trial and developing trial strategy with your client is to understand the body of evidence against you and to strategize around that. Because trial counsel didn't do his job and investigate these text messages, he didn't have everything he needed to develop effective trial strategy. And thus, had trial counsel done that, I would argue that both the mistake of fact and the consent instructions would have been appropriate.
So I don't know if you can shed any more light on this, but since we're talking about the consent instruction that you want, or that you thought should have been added, what consent are we talking about? Are we talking about consent to or to come into the home? Or are we talking about consent to have sexual activity?
Well, similarly as brother counsel, Your Honor, I hadn't really approached the issue from that particular angle. In my argument, I'm speaking about consent with respect to the sexual activity. But second, it's true that we haven't found a golden ticket text that says, come on over tonight and let's have sex. But as I discussed a little bit earlier, this 286 messages was 6% of their total communications during this time, roughly 6%. And that simply does not give an accurate idea of their relationship, both with respect to consent to the sex or consent to come over to the house. And so the fact that there isn't that silver ticket specific text messages doesn't destroy that argument. And finally, I just wanted to assert that even divorced from Ms. Rosen's testimony of as to the number of people that she had dealt with, the statistical figure that she gave is really what we take issue with in this case, and really what we'd like the court to focus on. But beyond that, I'm happy to entertain any other questions you have. But other than that, I'll happy to rest on my brief.
Any other questions? All right, thank you very much. Thank you both for appearing. Appreciate your arguments. The case is submitted. Mr. Morton, you can head back to the Williams Building and lick your wounds. Did a great job. Thank you.
Well, what do you mean?
Okay, I'll call item 3, docket number 367-082, People of the State of Michigan versus Willie James III. Counsel for defendant appellant, Ms. Young, will be appearing via Zoom.
Good morning, Your Honors.
Morning, we can hear you. We can't see you as of
Can you
yet.
see me? All right, hold on here.
Give us a moment. Here.
Okay.
Okay, there you are.
Yep.
All right.
All right.
Why don't you go ahead, Ms. Young, give us your appearance and you may proceed.
Okay. Laurel Kelly Young on behalf of Willie James. And I am going to rely on my brief. However, I think it bears repeating that he asked for a manslaughter jury instruction and he was denied, when it would have applied in this situation. And also that the jury sent out a question, says, can't we convict him of manslaughter? And so I think that shows the insight of the jury that, they didn't want to come back with a not guilty, but they were, second degree murder was their only choice. So any questions?
Ms. Young, wasn't the defense at trial that he didn't do it? It was a question of identity.
Yes, there was a question of identity.
So how would that square with a manslaughter instruction where he would have essentially had to say, yes, I did it, but I didn't have malice when it happened? It was a heat of passion type situation.
Right. Well, I do believe that you can argue in the alternative, and
I think you can too, but he didn't. I think that was kind of the conundrum that the trial judge was in, and that nothing he had said throughout the trial or defense strategy lent itself to manslaughter. It was all, I didn't do it, I didn't do it, I didn't do it.
yes, but when you look at the testimony of, I think it's a girlfriend who he had made admissions to, that he was afraid and he had one leg, and that, he knew that these people carried guns,
If
in
that
that
was all
environment.
we had, that might be a plausible argument, but in this case, I think your client testified in his own defense. So, right? So, I mean, he never said, well, gee, I was scared for my own life. These guys were my mortal enemies and I thought they might get the drop on me. He didn't say that. He said, it wasn't me. I wasn't there. So I think, arguing that theory is significantly undercut by his own testimony. I'm afraid. I don't even know that there's a question in there, so. Anything else for us, Ms. Young?
No.
Okay, counsel.
Morning, Your Honors, and may it please the court, Christopher Cannell appearing on behalf of the County Prosecutor's Office. With regards to the manslaughter jury instruction, the defense, as you noted, was obviously it wasn't me. But we have Simba's testimony, which potentially could create that defense, but in order to bring that forward as a defense for manslaughter, you then have to abandon the "it wasn't me" argument, because it's either credible testimony for both positions or it's not credible in either regard. But not only do we have his testimony of saying, it wasn't me, I didn't do this, but we have the surveillance video that eliminates any sort of argument that he had, that there was provocation or that this was heat of the passion. The video shows him entering the store and immediately reaching for his firearm. It shows the victims at the store counter backing away from him when they notice him. And he's at the door, halfway out the door, when he draws his firearm and starts shooting. And he takes one more step after that and the door closes behind him. So not only is the instruction, directly contrary to what his defense was at trial, but it also was just plainly not supported by the evidence in this case. As far as the remainder of the arguments, I believe my brief is responsive to all of them. So unless the court has any questions, I'll rely on my brief.
Questions for Mr. Candela? I don't see any.
Thank you, Your Honors.
Ms. Young, any rebuttal?
No rebuttal.
All right. Thank you very much.
Thank you.
For appearing today. We appreciate it, and the case is submitted. All right, that brings us to item 4. Docket number 368093, People of the State of Michigan versus Brad Cornaya.
Good morning, Your Honors.
Good morning.
Michael McCarthy, P30169, appearing on behalf of the defendant appellant in this matter, Brad Cornaya. I raised 2 issues in the brief of appellant. They're really intertwined. The first issue has to do with the admission of the 404B evidence. And this is a case where, first of all, there is no body. Ms. Luth, the decedent in this case, or purported decedent, hasn't been seen since November the 10th of 2008. And after the statutory period passed, the Ingham County Probate Court issued an order to the effect that she was deceased. Now, that's not a finding of how she died or what the cause of her death was or the manner of her death, but just a finding that I would submit, because it is under the purview of the probate court, to deal with one's property after their demise if there's no finding of a body. This is a different circumstance. We have a homicide charge brought, first or open murder, and for which Mr. Cornaya was convicted of first degree premeditated murder. There still is no body. There is no explanation, no evidence in the record to show how this individual, even if she is dead, actually died. There was no testimony from a medical examiner talking about the manner or the cause and the manner of death. There was no testimony from any person who saw this individual, my client, commit any crime. So what we have is a circumstantial case. And the reason why I submit the people brought the or proposed to bring the other act's evidence is because of the holes in the body of proof that the people had in order to prosecute Mr. Cornaya when they brought these charges, or this charge against him. And so looking at what the other evidence actually was, we have 2 things. One is that he used Ms. Luth's credit card to engage in some telephone sex with some person whose identity is unknown, but some pay-for type of service, and that made her angry and led to the breakup between the 2 of them. The second piece is complete.
So before we get to the second piece,
Yes.
For the first piece, why was that? So they offered the evidence to go to motive, maybe among other things. Why was that an improper non-propensity reason for that 404B evidence?
Well, I think there's 2 things. One is it is, when we look at, even if evidence is non-propensity, you still have to do the 403 balancing. And I submit, and I argued in my brief, that it's much more unfairly prejudicial.
Okay, so it might have been offered for a proper purpose,
May
i.e.
have been.
motive, but you think it was unduly prejudicial.
Definitely, and that's what I've argued. And your point is well taken. You could say, okay, well, there's a reason here. But what it does really is it puts Mr. Cornea in a very bad light because
But, I mean, I don't mean to belittle it, but you know, there's no indication that this, you know, sex call 3 days before they broke up was illegal. You know, maybe it was one of those where you see it on the poster or something, you call the number. You know, it might have been a good reason for her to break up with him, but is it really that prejudicial? It's not, again, I don't think there's any question that it was unlawful.
Especially in the context of a first degree murder
Yeah.
case.
I
mean,
agree.
maybe you could argue
The
it's
balance.
And if we had a
immoral or
body,
something.
and there was a medical examiner saying that this, yes, this person is dead and the cause is homicide, then that would be a totally different deal. But we don't have that. And instead what we have is the prosecution filling holes in their case in chief with other acts evidence.
Well, you're asking us to buy the argument that the jury would have convicted him of homicide because he called a 1-800 sex line. I fail to see how that piece of evidence would have tipped the balance in favor of the prosecution in this.
Well, there are two pieces of evidence.
Well, I know.
The second piece of evidence is more outrageous. This is, and it's complete, and the reason I say outrageous is he makes an obscene phone call to some woman whose name never was revealed, as I recall my reading of
was.
the transcript.
I know it.
You
It's in the
did? Well,
record
then,
somewhere.
whichever it was, the fact of the matter is that evidence came in, that call was made 2 days afterward. She reported it to the police and he goes and he talks to the police. He didn't run away from anything, but I
Well, he
asked.
ran
him-
away from the fact that he had two cell phones with two different numbers, one of which he never disclosed to them, wasn't it?
Well, there is that piece of evidence, but the fact of the matter is, he did sit down and talk with the Meridian Township Police Department to address that issue. The Michigan State Police investigator watched that interview. He also spoke with the Michigan State Police investigator regarding Miss Luth. So he wasn't hiding anything there. And in fact, it is very, I think, important as to this particular issue that the people, excuse me just a second, pointed out that the obscene harassing phone call may be considered, this is from the jury instruction that was given as to this under 411, the Michigan jury instruction, for concealment of evidence and consciousness of guilt. So consciousness of guilt for making an obscene phone call is arguably okay, but consciousness of guilt is what we're really talking about here is Mr. Cornea's purported consciousness of guilt of a homicide.
Well, I mean, even though there's more details in the record, I don't think the jury was told much about this obscene phone call, you know, in terms of the details, what was said, and most specifically who it was to, because it was to a public official who I think is pretty well known in this area, which arguably would have been more prejudicial if those details had been given to the jury. So the jury was given pretty plain vanilla instructions with regard to this in terms of it was an obscene phone call. Meridian Township talked to him. He never, you know, indicated that he had these, to Judge Boonster's point, he had these various phone numbers. Again, so what's the, I mean, there's prejudice. There's no doubt there's a little bit of prejudice there, but it's not the most salacious or damning other acts evidence that we've seen, for example, in other cases. So what was just so prejudicial about those two pieces that a jury would convict him of homicide?
We have the testimony of the police officials who conducted interviews with Mr. Cornea in the record. They both gave testimony. So this isn't a case where the people don't put the defendant's statement in. They did put the defendant's statement in. So they've got his statement. Why is it that they need on top of that other acts evidence? And I submit that this combined with the fact that you have no body and you have no manner or cause of death in the record, this is filling in holes having to do with those missing elements, as I've said before, that's why using this other act's evidence in this case, under these circumstances, is much more unfairly prejudicial than it is probative of the truth. Your point that this isn't, or maybe it was your point, Judge Cadola, that it wasn't the first item that I raised an objection to was not the thing that tipped the scale. Let me just take that and say, oh, that's fine. But two of them together, and we're looking at these holes, but we got a lot of other testimony given. I think that it does cause the scale to tip unfairly against the defendant and caused his death. I mean, it caused his conviction. And the other point that I would make, and I said in the beginning of my argument here this morning, that the second issue really follows on the first. And I will rest on what I have said there, but I'm happy to answer any questions regarding the sufficiency of the evidence, because I think that I've pretty well covered it, at least perhaps inadvertently, in my argument in support of question number one.
Any other questions for counsel? All right, you will have time for rebuttal.
Thank you.
Good morning, Your Honors. Special Assistant Prosecuting Attorney, rather, today, appearing on behalf of the people and for the Ingham County Prosecutor's Office.
You didn't give us your name.
Kayla Crino. First thing I want to do today is recognize a few people who are in the gallery. With us today is the victim's father, Roy Duluth, the victim's brother, William Crino, the Deputy Chief Prosecutor for Ingham County, who is trial counsel in this matter, and one of the lead detectives, Tom DeClercq. Brad Cornea, in his appeal, raises two issues. First, that the trial court improperly admitted evidence under MRE 404B, and second, that there was insufficient evidence to support that conviction for first-degree premeditated murder. I'd first just like to open it up for questions from the court regarding the 404B argument. I listened to the questions for opposing counsel. I can tell that the court really has a grasp on what these things were admitted for and what they weren't, but I'd be pleased to answer any questions about it.
I think
least
the
in my
argument
mind.
relates to 403 more than anything else, so maybe you can address 403.
Yeah, I'd be happy to address 403. So, 403 deals with whether the evidence was, whether there was a danger of unfair prejudice to the defendant.
While you're addressing that,
Yeah.
the one, and I want to piggyback on Judge Boonster's question, I very easily see the relevancy of the credit card and the sex call 3 days before as motive. I'm a little less certain about the second piece of 404, the other acts evidence in terms of the obscene call. So when you're addressing Judge Boonster's question, can you also explain specifically why that second piece of evidence was particularly needed here?
Yeah, I can do that. So in doing that, let's just back up and go straight to your question, and then I'll go to Judge Boonster's question. So, as to the second item of 404B evidence, that's our November 13th, 2008 obscene phone call, and what followed on November 14th, the interview that followed. This was offered for the proper purpose of showing Cornea's destruction of evidence, consciousness of guilt, and ultimately how those things relate to his identification as Krista's murderer. So it was the investigation into that phone call that he made that ultimately led to investigators discovering the true nature and the true frequency of Cornea's communications with Krista on November 11th, learning that Cornea had lied about the phone numbers that he had during that time, and learning that Cornea had destroyed the phone that he used to make those phone calls to Krista on November 11th. And in context, it's sort of
Was that the same phone that he used to make the obscene call?
different phone numbers, actually. So he had 3 different phone numbers. One is used for the obscene calls. One is made for the communications with Krista and also with Todd Olson.
I think Judge Swartzel asked if it was the same phone. You went to phone numbers, so maybe you can clarified.
I don't think I can clarify that
Okay.
point because, one of the things that we know from the record is that Cornea switches around SIM cards with quite a bit. And he destroyed these phones before the police even got to the point where they could possibly seize one of them. So I can't stand here and say, did he have two physically different phones? I would presume most likely he did, but I can't say for certain because they were never recovered. So if the police had never linked Cornea to that phone and that phone number, just for clarification, the one I'm talking about now is the 517-455 number, they would not have known that he harassed and stalked Krista throughout the day on November 11th, right up until the moment when she disappeared, or that he appeared to be doing that while he was lying in wait in the very area of Krista's home, or possibly even inside of the home. They might not have discovered that he was using this very same phone when he encountered police on US 127 in the very area where Krista's own discarded phone, identification debit card, and possibly glasses were later located. And that when he used that phone, it was hitting off of the very same tower where Krista's phone connected to a cellular phone tower for the very last time. So the manner in which Cornea hid this phone number from investigators in Krista's case, that is, failed to tell them about it in his November 15th interview, and then failed to tell them about it in his November 19th interview, and then ultimately how he destroyed that phone that was linked to that phone number, directly demonstrated his consciousness of guilt, his efforts to destroy evidence that would link him to Krista's murder, and ultimately Cornea's identity as Krista's murder. So no one is saying that because Cornea made an obscene phone call, that means he has a consciousness of guilt for murder. It is more complicated than that, but it is ultimately the investigation into that phone call that leads them to discover the very things that are evidence of his consciousness of guilt and the destruction of evidence that we know he engaged in. And it even becomes even more apparent when we get to Todd Olson. So Cornea, the defendant, was using this same 455 phone number to communicate with Todd Olson. And in doing this, he appears to be engaging in something related to disposing of Krista's remains. Before leaving the area of Krista's home on the night of the murder and the disappearance, Cornea uses the phone to call Todd. And when his car breaks down, he uses that phone to call Todd. And the next morning, when he's in the area of the Gunnell Road hunting property, he also uses this phone to talk to Todd. And then right before the November 14th interview with police about the November 13th obscene phone call, he also calls Todd. But then after that, he doesn't use the 455 phone number again, and he doesn't use it to talk to Todd Olson again either, even though that is the phone that they typically use to speak to one another. So ultimately, this November 13th obscene phone call was properly admitted for an appropriate purpose under MRE 404B. And then that takes us, of course, to the court's prejudice question, and I'll address both components of the 404B evidence as it pertains to prejudice. So first of all, it's really unlikely that Cornea's use of Krista's credit card to call an adult entertainment hotline on November 6th or the obscene phone call on November 13th caused the jury to react with bias, sympathy, anger, or shock, or some other similar emotion that would cause them to convict Cornea of first-degree premeditated murder because he engaged in these two ultimately, by comparison, rather benign actions, particularly, and this goes to the November 6th incident, because he paid Krista back that same day for the act of using her credit card number. So while, of course, I would concede that you're not allowed to use someone's credit card number without their permission, the seriousness of that was dramatically reduced by the evidence that showed Cornea paid her back for that expense immediately afterward. And ultimately, calling an adult hotline, as the court's already pointed out, is not something that is illegal. It's not criminal. It's something that, by itself, absent the use of the credit card, adults are allowed to do that. In contrast, it probably would have been clear to the jury that there was something criminal about Cornea's obscene phone call, and that's because the police ultimately investigated it. The jury didn't hear who the recipient was. The jury didn't hear the name of the hotline that was called or any of those details that might have amped up the possible danger of prejudice here. But
Did the jury hear any of the content of what he said?
they did not.
Okay.
They did not.
They just, what were they told? Just that the police had investigated an obscene phone call made to a person in Lansing?
That's correct. And, you know, that gets to something that I've been thinking about, because when you consider were the options of things that could have been told to the jury about that, they needed to hear something to explain why are the police investigating a phone call. So it wouldn't have been possible to entirely clean out the nature of it. They could have been told that it was a somewhat threatening phone call. They could have been told that it was unwelcome. They could have been told that it was harassing, and all of those things would have been accurate, but perhaps a little bit more prejudicial than the word that was chosen to describe it, which was simply obscene. And so that was just enough information to give the jury appropriate context for why the police would be investigating this phone call, but not clean it out so much that it's essentially a fiction and they're left wondering, you know, what is this even for? You know, ultimately, the focus of that particular incident is really what Cornea hid from the police in his interviews regarding Krista and what he revealed in the interview regarding the obscene phone call. So these things were highly probative of Cornea's consciousness of guilt, of the destruction of evidence of his identity, and ultimately the danger of unfair prejudice was quite minimal. Additionally, you know, under our 404B analysis, there was a limiting instruction. That instruction properly told the jury what they could consider these other acts for and what they couldn't. And there was no argument that was outside of the parameters of that instruction or the court's 404B ruling. I touched on this a little bit already as to the obscene phone call, but for the call to the adult entertainment line, I know that in the defendant's brief and a little bit implied in the remarks today is the argument that, you know, the sexual nature of this should have been cleaned out entirely. There's really nothing that entitled the defendant to redactions of that level, because the sexual nature of that call is ultimately the thing that was most relevant to the defendant's motive, because that's why Krista broke up with Cornea. And sanitizing it any further than what the people already did in this case would have really obscured the defendant's true motive here.
I forget, was there other corroborating evidence that that's why she broke up with him? Or was that simply the prosecutor's theory and this one piece of datum?
Eventually, he admitted that that had been part of the reason why Krista broke up with him. So in one of his interviews with the police, I think the one on November 19th, is where he ultimately does admit to that being part of it. And it was also corroborated through some of the evidence that was put in about Krista's life and her sudden disappearance and the friends that she was talking to. I think she had revealed the nature, some information about the nature of the breakup to her friend Murray. Are there any other questions, I guess, before we
Well, I
depart?
wanted to ask specifically about that last point. Was there ever, you seem to indicate yes, that there was some testimony that the friend with whom she had dinner and then brunch the next day, Murray, had indicated that this was the precipitating factor in the breakup. Is that, did she so testify or not?
I think that's taking it a little
Okay.
bit too far. She told Murray about breaking up with Brad. I
Right.
don't know for sure
know
if she
that
told
much.
Murray, if
Why?
it is within the record that she told Murray why.
Okay.
But ultimately, that is part of the defendant's interview and the things that the defendant eventually revealed in the November 19th interview.
Clarify.
Okay,
Thank you.
very good. So moving on to Cornea's argument that there was insufficient evidence for the jury to convict him of first-degree murder. When the evidence is viewed, of course, as it must be, in a light most favorable to the prosecution, and making all reasonable inferences and credibility choices in favor of the verdict, there was indeed sufficient evidence of the defendant's guilt and sufficient evidence for a rational trier of fact to conclude that the essential elements of the offense were met. And this was a trial that certainly involved both direct and circumstantial evidence. And importantly, it's for the jury and not for appellate courts to determine what inferences may fairly be drawn from the evidence and to determine the weight that will be accorded to those inferences. And circumstantial evidence and the inferences based on circumstantial evidence can provide satisfactory proof for the elements of a crime. And that's language we're all familiar with, but I feel it bears repeating an emphasis here, because in a no-body case, it would indeed be rather easy for the jury, if they were so inclined, to not reach a unanimous verdict or to find a defendant not guilty in a case where there is indeed no body and no witness to exactly what the defendant did to the victim. Those options were available to the jury here, just as they were in any other case. But instead, the jury evaluated the evidence, both direct and circumstantial. They made appropriate inferences from that evidence, and they convicted the defendant. So Cornea challenges all of the elements of first-degree murder here. So I'm happy to take questions at any time, but I plan to briefly address each of those elements. The defendant challenges evidence, both in the brief and today, an argument that Krista is actually dead. Well, what the jury heard about that is that she disappeared without a trace, and that when this happened, she was living a full life that included educational pursuits, employment at a civil engineering firm. She had short-term plans. She had long-term plans. She had friends. She had family. She had a full life. But after she disappeared on November 11th, no one ever heard from her again. And that sudden, extreme disappearance indicates that she's dead and that something happened to her which was against her will and her intentions for her life. And while it's true that from a disappearance alone, there are other things that a jury could have possibly inferred. But the reasonable inference here is that Krista disappeared and never spoke to her loved ones again because she was unfortunately dead. But there was more evidence besides just her sudden disappearance. More importantly, items which were intimately connected to her life, to her person, were discarded on the road 13 miles from her home within mere hours of her disappearance. And the jury was from that free to infer, free to conclude that her phone, identification card, debit card, and perhaps eyeglasses would not have been on the side of the road 13 miles from her home unless she was deceased and those items had been taken from her.
Am I correct that within somewhat close proximity to where these items were found, there was something etched in a tree that indicated both the victim's name and the defendant's name?
Not at this location.
Which location?
But at a hunting property off of
Okay.
Gunnell Road, and that's the same location. There was a culvert there, and at hunting season in 2008, ultimately there was a witness who observed two people burning some type of a fire in a culvert. And then one of the things that happened later in the investigation is they did excavate that culvert. They found some charred wood in that area and a cadaver dog hit on that same area. And very close in proximity is the memorial that the court is thinking of.
Oh, the items were located near where the defendant's car broke
Right.
down.
Yeah,
On
this,
120 or off of 127?
yeah, all
Yeah.
these remote sort of Ingham County adjacent locations. So yes, in that location is where the broken cell phone, which had been broken into pieces. Each piece was on a different side of the road, glasses, ID card, debit card. And those are items, at least as to the cell phone and the debit card, that we know she was using earlier that day because of the financial transactions that were presented to the jury. So she had these things, she used these things earlier. In the moment when she disappeared, suddenly she doesn't have these things anymore, and they're then located on US 127 at the very location where the defendant had an interaction with police because his vehicle broke down. So in oral argument, opposing counsel mentions the Ingham County Probate Court declaring that Krista is legally deceased. That's certainly a part of it. That's something that the jury can consider, that the Ingham County Probate Court opened a file and found her deceased, but it's not just that. That's not why we know she's dead. It's that. It's her items, it's her sudden and extreme disappearance, and it's that since the moment she disappeared, there has been absolutely no credible evidence to indicate that she's alive. And law enforcement looked at the databases that were available to them to make that determination. They used facial recognition software and found absolutely no evidence that she was alive.
So counsel, what supported the premeditation element of first-degree murder? I think that's sort of the biggest hurdle.
Yes, absolutely. So I guess what I would say is, you know, the evidence of premeditation is linked to the evidence that an act of the defendant caused the death. It's all sort of intertwined. So if I can address both of those elements sort of at the same time, you know, the elements of first-degree premeditated murder, first of all, do not require that a prosecutor prove the precise nature of the act that ended the victim's life. And that's why the jury instructions in this case were modified so that there would be no confusion on that point. So in terms of evidence that the jury had to consider for whether it was an act of the defendant and ultimately with premeditation, intent to kill, and deliberation, ended Krista's life. In determining who, if anyone, was responsible for the act that ultimately ended Krista's life, the jury heard that Cornea did not want his relationship with Krista to end, that he tried unsuccessfully to have that relationship continue, and that he failed in those efforts. And this is not old news or something that was going on weeks and months before. This is what was going on exactly when she disappeared. So it's contemporaneous. So first of all, we have a motive that's indicative of his premeditation and his intent to kill. But it's more than just motive, because Cornea's actions on the day of the murder also indicate that she died because of an act of the defendant with premeditation and deliberation. Leading up to perhaps the very moment of her disappearance, the jury heard evidence that Cornea was in the area of Krista's home, or perhaps even in her home, based on the way that that his cell phone was connecting to the cellular towers. And it is very reasonable, it would have been very reasonable for the jury to conclude, based on the nature of the communications that Brad was sending to Krista, the frequency of the communications, and his location, that he was lying in wait for her and that he was harassing her by calling her and texting her repeatedly during that time. And while it's true that they didn't have to reach that conclusion in the context of the breakup, it's a reasonable inference for the jury to make. And Krista and Cornea were then on the phone together at 5:11 p.m. that day. During that call, both phones are utilizing the towers in the areas of Krista's home. Krista had left Michigan State University by that time. She had headed home, and we know that she didn't leave for her 5:30 class that day at the community center because her binder for that class was left in the home. Silence is also evidence of an act of the defendant causing Krista's death here, and ultimately defendant's premeditation and intent. So between 5:11 p.m. and 7:10 p.m., both Krista and Brad's phones are all of a sudden silent for 2 hours. And after that, Cornea starts using his phone again, but Krista never again does. Cornea calls his voicemail while still connecting to the towers in the area of Krista's home. And then he starts traveling south, and he calls his cousin twice, seeming to travel again south toward US 127 and the area where he ultimately discards Krista's things. And shortly thereafter, at 8 p.m. is when all of this occurs. Cornea's vehicle breaks down and it's towed away. So there's no credible evidence that Krista's body was in the Bronco at that time. And that's essentially because of how the tow happened, the tow driver getting into the vehicle, the way that it was lit up. But what we do know was in that vehicle, So quickly after Krista's complete and absolute disappearance is the ID card, the phone, and possibly the glasses. And from that evidence, it would have been reasonable for the jury to conclude that for Cornea to have possession of those items, for him to want to dispose of them in the manner that he did it to attempt to hide what he did. And that's indicative that Krista died because of an act of the defendant.
And counsel, I suppose you're taking us through all this post-offense conduct because under Michigan law, that can be admitted to support, an inference of premeditation to support first-degree murder. Am I correct? in
That's
that
absolutely
statement?
correct. And that's under People versus Oros, which tells us that when we're considering a sufficiency challenge specifically to premeditation and deliberation, the question is whether the evidence introduced at trial fairly supports an inference of premeditation and deliberation.
Which would also include the conduct that allegedly occurred at the hunting property.
Yes, that is exactly correct. And that was evidence that the jury could draw from to conclude that it was an act of the defendant with premeditation and deliberation that resulted in Krista's death. So, essentially they have everything that I've taken the court through, everything that I've discussed, the defendant lying in wait for Krista, her coming to the very area where we know that he was lying in wait, and for her disappearing completely and entirely in that moment, and then Cornea disposing of things that are so intimately connected to her life, right in a moment where he's about to have police contact. So someone having committed a murder and holding on to those items, that's the moment to say goodbye to them. That is evidence that he was hiding what he did, that he was trying to get away with what he did, and that he had ultimately committed her murder.
And he made no attempt to contact her after that time, is that right?
That's exactly correct. He made no attempt to contact her, this person who he apparently loved so much and wanted to continue having a relationship with. After that 5:11 p.m. phone call that they had, he never called her again. And, that also brings up some of the things about his demeanor during his interviews with the police, right? So yes, never calls her again. And then in his interviews on the 15th and 19th, he's extremely unhelpful. His reactions are unusual. He goes to great lengths to portray her in a negative light. He lies about the contacts that he's had with her. He lies about his phone. He, lies about or fails to share information about what his conduct was the next day on November 11th, everything with the hunting property, everything with Todd Olson, and all of that can ultimately be considered for the element of premeditation and deliberation. And so under the standards of People versus Oros, the facts were absolutely sufficient for the jury to convict the defendant of first-degree premeditated murder here.
I think we understand the
Very good.
record and the issues very thoroughly.
Very
Is
good.
there anything
There-
else?
There
you
is
feel
nothing else
you
that I
need
would
to-
share with the court. Thank you, seriously, thank you very much for the court's time, for its consideration, for listening. It means a great deal, I know, to the Ingham County Prosecutor's Office and also to the victim's family in this case. So thank you.
Counsel, any rebuttal?
Just have a couple of points. This name Todd Olson is interesting. I raised this in my second issue, but the fact is that on the same day, as I understand the record, that Ms. Luth broke up with my client, Mr. Cornea, she also broke up with Todd Olson. There's communication between the two of them. The record set forth in my brief is what the relationship with her, between her and Todd Olson was. Todd Olson also it wasn't clear that he was actually going to testify during the trial. There was, outside the presence of the jury, his waiver of his rights to silence under the Fifth Amendment before he actually took the stand. The business about the heart with the arrow through it, or the initials on the tree, that's on that hunting property that through Mr. Wilson, or Olson rather, Mr. Cornea had access. There's no statement, there's no testimony, there's no evidence that says when that happened. And I would submit that it's just as reasonable to say that that is something that was done when the two of them, Miss Luth and Mr. Cornea, were together in the woods while they were alive together and enjoying a good relationship at that point. There's nothing in the record that would make that impossible any more than what is argued here is that it was perhaps him doing that after she died.
Well, it happens to be very nearby the spot on the culvert where the bonfire, I'll refer to it as, appeared to have taken place.
I understand that. No body found by this culvert, this business about a dog hitting on some spot. Well, you know, that's not, you can put it into evidence, but it's not any proof that there was a body there. Who knows that the dog is so brilliant that he's 100 or she
I think
is
we
100%
all know
accurate.
it's a circumstantial case.
Right.
Because it's a no-body case. So
That's
by
exactly
its
correct.
nature, it's circumstantial, and people are convicted of all manner of crimes based on circumstantial evidence, which
I understand
I'm
that.
sure you know.
One other point that I want to make, and that's about November the 10th. That's the day, and we had two witnesses testify about this during the trial, the people from Leo's restaurant. Well, Mr. Cornea has dinner with Ms. Luth in that restaurant. They were both well-known there. There was no indication that there was anything argumentative going on between the two of them during that meal, which he paid for. And he also, as I understand the evidence, took her back to her place of employment, and which is something that he customarily did. And this is after she announced the breakup. So the motivation that he is so incensed because she broke up with him and now he's going to kill her as a result of that, in the context of these other facts that were all part of the record, makes me still question the sufficiency of the evidence that supports him being found guilty of first degree.
That was all before the jury and they weighed all of that. Right?
Well, did they? And that's my question. And also, I mean, I leave it to your honors to make a decision here, obviously. I appreciate you listening to the arguments that I presented there. This is the only no-body case I've ever dealt with at this level.
Thank you
Thank you.
very much. We appreciate your arguments, well argued on both sides. We
Thank you.
appreciate it very much. The case is submitted. Thank you to the family members and the other officials for being present in the courtroom today. We appreciate it. I did, yeah. Item 5. Docket number 369338, People of the State of Michigan versus David Joseph Ron. Thanks.
Yes.
Calling Ram at
Number
your
5.
request. As it is now past 11:30.
Barely.
Sure. Going back to our natural order of things.
Yes, Mitch Foster for David Rom. So for the most part, Your Honors, I will be resting on my brief. However, I did want to get into some detail on the facts, and specifically the facts of the defendant's statement to the police, to Captain Moore. And I take issue with both the trial prosecutor's closing argument, as well as the representation in the prosecutor's brief on page 18. I believe both are very misleading. So if you look at page 18, there was 4 alleged quotes from Mr. Rom from the recording. The first was, "It could have happened." The words "it could have happened" were never on the recording, and Rom had never said those words to Captain Moore. That's very important to consider. Rom was only talking about times when he was impaired and would not have remembered anything. He never made an admission. He didn't remember anything about when he was impaired and passed out. Now, Moore's testimony at trial, if you look at the transcript on page 48, did not match Rahm's statement in the interview. So Captain Moore stated, but yes, the mouth on the penis thing and the porn thing could have happened. So yes, he said it did happen. That is a false statement and false testimony when you put that side by the recording. And the trial prosecutor never corrected that record.
Was the recording played for the jury? Relevant portions of it? I don't,
It's my understanding it was, but I'll defer to the record.
I believe it was. And so, I mean, I think you have legitimate arguments that the prosecutor, characterized it in what you would argue is, mischaracterized it. Prosecutor would argue, well, reasonable inferences and such. But at the end of the day, the jury heard the relevant portions of the recording and they could draw, their own inferences regardless of how either party frames it. And so isn't that the key issue? The jury, and they were instructed to draw their own inferences and that the lawyer's arguments were not evidence.
I agree, Judge Schwartzel, about that, but what the point I'd like to make is, and I listened to that over and over again. At least, I would go back and I'd listen to 30 seconds to a minute. I'd go back and I just couldn't get to, and even in the light most favorable to the prosecutor, giving all deference to their arguments and what inferences, I just couldn't get to the inferences that they were drawing. And your point is well taken, but this wasn't like rapid fire question, clear answer. This was kind of like a meandering narrative, and it was going on and take things. When you look at the full context, you see what he's really saying. And there was never an admission about any crime ever at all when you look at the context. That's the bottom line. And the jury may have only heard it one time. The volume may not have been loud enough. And if you hear it one time and then you juxtapose it with the testimony of this captain from out of state.
But now do you know whether the volume was high enough? Do you know whether it was played so quickly that the jury couldn't have drawn his own conclusions, or are you making suppositions here? Is there anything in the record to suggest that the volume was not high enough for the jury to hear?
No.
Okay.
But not that I'm aware of. But there's also no indication in the record that it was played more than once. And there's also no indication in the record that I recall that the jury requested that it be given to them in the jury room. I don't recall if they gave all the exhibits to the jury room, to the jurors for deliberation. But my understanding of the record is it was played once during the trial and that was it. And then when you put that next to Captain Moore's false testimony, I think it's clearly false testimony. And then you combine that with the prosecutor's blatantly false representation of the facts. Maybe the jury didn't want to have to hear if the recording is what it was said in the prosecutor's closing argument. Maybe the jury wouldn't have wanted to hear those details because, well, this is what the prosecutor said. He's an honorable person. He's not going to lie. He's not going to mislead us. That's what happened. And then, interestingly, I didn't bring up ineffective counsel, but my client in his standard 4 brief did represent ineffective counsel. So the failure of the trial counsel to object to the prosecutorial misconduct, I believe, can properly be considered by this court when you combine my brief and my client's brief. But I don't have a lot of confidence that the jury went through and analyzed this recording. Because like I said, I went through it a number of times, both when I wrote the brief and as I was preparing for the oral arguments, and I just couldn't get there, couldn't get anywhere near reasonable inferences. And the second part, pretty solid on not doing anything like that on purpose. Well, those words the defendant, Mr. Rahm, did say, but when taken in full context, Rahm was referring to being passed out watching porn he never admitted to any memory of oral sex. So he never admitted to that. And, you know, unfortunately, I've had a lot of cases like this at the trial level as well as in this court. And sometimes you hear an argument, well, I was asleep and she started giving me oral sex and I woke up. You know, that's a defense. And maybe it just continued too long. It was nothing even close to that. When he was specifically asked that by Captain Moore, he emphatically and clearly stated, no, didn't happen. So you have that clear no. And that's another thing. The trial prosecutor said he never denied it. He admitted to the oral sex, but he denied the anal sex. Well, that's not true. He denied, I think I listed 13 times he denied. Maybe 11 of those were the oral sex and the last 2 were the anal sex.
So, I mean, what you're really arguing about is the way this was characterized by the prosecutor at trial. But, you know, the jury heard the complainant testify and heard the recording of the interview, and they were able to they could have reached the same conclusions you would have us reach about the interview, that there was no admission. They returned a guilty verdict. And furthermore, they were instructed that what the lawyers say is not evidence. So I'm struggling to see what the reversible error is here.
Well, and that's a good point, Judge Godola, but I mean, where do you draw the line? I mean, could the prosecutor argue anything? I mean, if you look at the Humphrey case that was cited by the prosecutor, says that if there's a curative instruction that could be countered, and there was no curative instruction because there was no objection, so that at least the ineffective counsel argument. But they say there is no need for a new trial unless it to be deterrence. And the reason would be it would deter future conduct. You can't have honorable prosecutors blatantly disregarding the truth and blatantly misrepresenting the record. And this court, I mean, why would you tolerate something like that? That is something that you have to draw the line somewhere. And when you're blatantly saying a defendant in a capital case admits to guilt with a child, oral sex with a child, that's 180 degrees from the truth. How can we tolerate that? I mean,
You say it's 180 degrees. I'd say it's somewhat less than 180 degrees, given the nature of what he said.
well,
At best.
I would strongly disagree with your interpretation, and I'm not saying that you wouldn't have looked fully at the record, but if you would have read it, listened to it one time or even 2 times, the full recording, it's easy to adopt the prosecutor's argument. Like I said, I went through it multiple times, and I had to really get to the point of finally figuring out the context. And this was the only thing that he admitted could have happened, was that she could have come in. He said there's a chance that NR could have seen something. Porn on the video referred to, some of them lesbian, some of them not, would be the type of the porn he's watching. And she could have come in and seen him, maybe his partially naked body, maybe seen something on the TV while he was passed out. He never admitted to any sexual conduct with her. What he did admit to was that, and that last argument was the part where it says not out of the realm of possibility at
Right.
36.3. So there was,
Let's point you to that. He said it was not out of the realm of possibility that NR was curious and did something sexual to him. And when the officer asked if there was a time when NR did something to defendant, and defendant told NR, it was not appropriate, defendant said, I want to say that I have. Anytime that it wasn't appropriate, it was just like a no, what are you doing? No, we can't do that.
Okay, and I appreciate that. I was gonna get to that next. So Captain Moore was very crafty. I mean, they made the argument that it was a non-leading, just tell me what happened, but she did sort of direct him when she transitioned, when he said it, you know, she could have, not out of the realm of possibility, came in, and seen the porn, and he described what, but then she transitioned. So when it happened, and then she just took that as an admission to something sexual happened, and then she asked her next question. So it was a very crafty transition.
Is it illegal to be crafty?
No, but it was misleading.
Oh.
I mean,
Police lie in interviews to suspects all the time. And I mean, it's not illegal.
she suggested in the nature of her next question that he admitted to something that he didn't admit to. So she didn't
I think
deceive
a
him.
fair reading is that he denied anything happened on multiple occasions, to your point, but that at other points during the interview, he certainly got close to the line, if not going over the line, of admitting that something could have happened hypothetically, maybe it happened. We talked to her about this, your parts are my parts, or your parts are your parts, my parts are my parts. I mean, there was enough there that you could draw the reasonable inference that he is at least strongly suggesting something happened. How is that not just a reasonable inference from what you would, I think what you started out by saying, it was a meandering interview?
Well, that's a good point, and that was something that I thought could have been a reasonable inference until I actually looked at it multiple times. And what became clear to me was this was the fourth argument that he admitted something in the prosecutor's brief. After it happened, your parts are your parts. That was the heading of the point. That was at 3654 of the recording. And there's no way to make any inference that this was about oral sex or any illegal act admitted to by Rahm. And that's the important part. The after it happened, if taken into context, any person that actually takes the time to analyze this recording, this statement, says that Rahm meant that NR would occasionally put her hands too close to Rahm's private area or her head too close to Rahm's private area. When he said, put her hand there, put her head there, possibly doing it intentionally, this was describing a child inappropriate, moving her hands without boundaries, and a parent and his wife talking about correcting a child that is too handsy or too free with private areas. And that's the part about your parts are your parts and my parts are my parts. That's what he told Captain Moore.
And I think that, that's a reasonable argument to make that defense counsel could make. But another reasonable argument to make is that he's indicating something happened and that after the fact, they tried to, somehow correct her or make sure in the future something didn't happen. And also, when he's asked about anal penetration, he's pretty emphatic, I think, throughout the interview, that never happened. When we're talking about the other stuff, he was much less emphatic and at one point said, hypothetically, something could have happened. And he, I think at one point viewed the suggestion that NR, they engaged in oral sex was much different than anal sex. So his very strong denial of anything involving anal sex versus his much, much more equivocal statements with regard to oral, I think, again, leads to just a reasonable inference that the prosecutor could argue, and defense counsel could argue all the points that you're making right now. Why is that not just fair arguments based on kind of a meandering interview?
I strongly disagree with your interpretation of the statement.
Okay.
So
how am I wrong?
you are wrong because Rom forcefully and unequivocally denied oral sex multiple times, right? Strongly, just as strong as the anal sex allegations.
And there's not other parts of the interview where he's much more equivocal with regard to oral sex?
I disagree with that because if you're making that statement and that you're adopting Captain Moore's interpretation of the
Not
interview.
adopting anything.
You're not-
I'm,
but
I'm
that's-
based on a review of that interview. How am I wrong? That he was equivocal at times with regard to oral sex.
As Captain Moore conflated the oral sex with, she could have come in and seen the porn on TV. And she could have come in and seen him when he's passed out from watching porn. If you look at it closely, every incident where the prosecutor, the appellate prosecutor, and Captain Moore are arguing that it was a tacit admission to oral sex, all of those, if you want to call them tacit admissions or realm of possibility, they're all unequivocally referring to the fact that he was passed out and that she could have come in and seen the porn on TV or could have seen him. But when she specifically, Captain Moore specifically asked about, well, could she have just started, sucking on your penis and then while you were passed out, he was very strong that no, that couldn't have happened. There was no possibility that that could happen. And I would urge all of you to just give it one more shot. I know you do thorough prep, you have staff, you read it, you watch the videos yourself. But if you look at them and stop and play those little snippets that the prosecutor cited in her brief, I would urge you to do that one more time. And you'll see 100% true that you can't make any reasonable inference at all in the light most favorable to a prosecutor that there was a tacit admission of oral sex.
We're not the jury, unfortunately for you. So, do you have anything else for us?
Well, again, I think that the trial prosecutor had a duty of candor to correct the record and to correct Captain Moore's overly helpful testimony to the
argument's been made.
prosecutor.
Anything
And-
else? All right, you'll have time for rebuttal.
I don't
Okay.
think there's anything
I
more
think
here.
that's enough. We'll
Thank
have time for rebuttal.
Okay.
Counsel.
Good morning, Your Honors. Monica Wilson, Assistant Attorney General on behalf of the people. Attorney Foster focused on page 18 of my brief, so I'll focus my brief argument there. It's true that initially Mr. Ram, I'm not sure how you say his name, denied, which I think is pretty common in police interviews. Anytime police interview a suspect, they initially deny things. But I think we've all seen in our experiences as defense attorneys, prosecutors, judges, as these interviews go on, I believe the word, Your Honor, Judge Schwartzel you used was meandering, where he initially did deny it. But then his denials turned into maybes, and then they turned into hypotheticals. And then as he kept talking, as I cited in my brief, which starts at 3654 in the interview, when he said, when it happened, I think you can reasonably interpret that as an admission. Because in the argument that was somehow about her viewing the porn, the further explanation of he explained to her, your parts are your parts, my parts are my parts, that wouldn't make sense if he's explaining to her about not watching porn. Like that explanation of talking to her about touching body parts has nothing to do with if it was when she walked in on him watching porn. So I think the reasonable interpretation of that statement is that, yes, that was an admission, that at least on one occasion she performed oral sex on
I
him.
think maybe more to that point in terms of the strength of an admission is his statement in response to a question. Should we talk to her? We being defendant and our mother. Should we talk to her? No, just see if she does it again.
Yes, and I
Again.
think again implies that it had happened at least once. So I think the prosecutor's comments are proper here because I think they're a reasonable interpretation of the evidence.
And correct me if I'm wrong, all of the relevant portions, at least the portions that we're focusing on here, were played for the jury.
Yes, so I think the jury got to view the interview.
Right.
And they could come to their own conclusions about, they listened to Cross's testimony, they watched the video, and I think it was up to them as finders of fact to determine whether or not she misled them, I think is the accusation, or that she was recalling the testimony. So I think those are just quintessential questions of fact for a jury to decide, which I think the reasonable inference from their verdict is they did see it as a tacit admission, and if they believed that the oral sex occurred, I think then they could make a finding that sufficient wise that the anal sex occurred as well.
Anything else?
So
I
thank
just
you.
I have one last question.
Yes.
You're not going to defend the use of the phrase right to be believed?
No.
Thank you.
Good. Any rebuttal, Mr. Foster?
Yes, just the part about when it happened. I don't think you can make any reasonable inference that that was referring to oral sex. If you look at the recording, it says that she was being inappropriate with hands and head, but it didn't say anything about in bed while they were watching porn. It didn't say anything about that. Didn't say anything about even that he didn't even have his clothes on. This was something that was very vague and general, and it didn't get into any specifics about any criminal act. And it was, he talked to the wife, and they said they're gonna, if it happened again, meaning if she's inappropriate, but nothing that he never admitted to he doing anything inappropriate or consenting to this. So that would just be the clarification I would like to say.
Okay, thank you very much. We appreciate your arguments. Thank you for appearing. The case is submitted. Yeah, no problem. Happy to do it. Okay, with that, we will take a brief recess and then come back for the remaining items, which would be items 6 through 9. So we'll take. Sorry.
The Honorable Court of Appeals for the State of Michigan is now in session. Please be seated.
All right, welcome once again. I'm going to cut right to the chase this time and call item 6, docket number 370091, People of the State of Michigan versus Scott Allen Franklin. I understand Mr. Branch, who's endorsed for the appellant, is not in the courtroom. So, counsel, you may proceed.
Good morning, and may it please the court. Assistant Attorney General Daniel P. Kelly on behalf of the people. In this case, Mr. Franklin asks this court to disregard longstanding precedent that defers to the fact finder's assessment of witness credibility. This court should decline that invitation. Mr. Franklin argues that the confidential informant lacked credibility, but he fails to identify any clear error in the trial court's finding that the informant was in fact credible. The trial court was in the best position to make that determination. It observed the informant's demeanor, considered his history, and ultimately found him to be both credible and reliable. Mr. Franklin points to nothing in the record that would justify second-guessing that assessment. Instead, he offers only conclusory assertions. His argument also ignores the substantial independent evidence, both direct and circumstantial, that proves beyond a reasonable doubt that he knowingly delivered methamphetamine to the informant. When viewed in the light most favorable to the prosecution and with all reasonable inferences drawn accordingly, the evidence leaves no doubt. Mr. Franklin knowingly delivered methamphetamine to the confidential informant on 2 separate occasions. Therefore, this court should affirm the conviction and sentence. And pending the court's questions, I would rest on my brief.
Any questions for counsel?
I have one question that's not really raised on appeal, however.
Yes, Your Honor.
Both you and opposing counsel refer to the sentence in this case as being concurrent.
Consecutive.
I'm sorry, consecutive. I find the judgment of sentence to be a little ambiguous in that regard, but I don't think it's supported in what the trial court said in the sentence, and I don't think it would be supported under the statute that he was charged under. I guess I'm wondering if you agree that it ought to be concurrent.
I did not research that, Your Honor. I don't know that I'm prepared to answer off the cuff on that. I believe that was from the judgment of sentence that it was likely pulled
Well,
from.
the
but I-
judgment of sentence shows both sentences starting on the same day. Shows no check mark on the box about consecutive sentencing, although it looks like it might have been whited out and then hand drawn without anything in it. And the box below that checks each other. So I find it unclear.
I would agree that that sounds very unclear. It sounds like that may be an internally inconsistent document. But beyond that, I don't have an opinion at this point in time that I can share with the court.
Do you know whether the trial judge at sentencing articulated that he intended to impose consecutive sentence?
I don't believe it, from my recollection, Your Honor, I don't believe it is that clear from the sentencing transcript.
And it would have to be very clear if it was consecutive, correct?
That is correct.
All right.
I don't think we have any other questions for you.
Thank you.
So thank you. That matter is submitted. Thanks for appearing and for presenting your argument. Okay, now we can get to our 11 a.m. call, now that it's almost 12:15. And the first item on the 11 a.m. call is docket number 370104, Mary Ann Lampkin versus Marshall Smith. And Attorney Skinner, representing plaintiff appellant, is endorsed and appearing via Zoom. Mr. Helm is here in the courtroom with us. Good afternoon. So we'll wait for Mr. Skinner to appear.
Judges, Mr. Skinner is in the gallery and I'm trying to promote him now. Here he comes, or he's declining to be promoted. You have to accept that, Mr. Skinner, to come in.
Didn't catch
There we
that
go.
last part.
He's come. Sorry, he's coming in right now, judges. Thank
Okay.
you.
Thank you. Mr. Skinner?
Good morning. Can you hear me?
Good afternoon.
Or afternoon, yes.
You can give us your appearance and then proceed with your argument.
Very good. Thank you, Your Honors. Michael Skinner on behalf of the Lampkins. I will focus only on the prescriptive easement issue, the first issue, a substantive issue in the appeal. If Your Honors have any questions, please feel free to interrupt me. I went through the different elements of a prescriptive easement. Wanted to focus on really a couple of points regarding that. There are multiple elements. The prescriptive easement is sort of a little brother to adverse possession. The elements of the two types of property right are the same except for exclusivity. So you're looking for something that's open, notorious, continuous, and you're looking for a 15-year period. The problem that the Smiths have is, well, as I put in my brief, they have a problem with every element really. But they bought the property in 2017. This suit was instituted in 2017. They alone cannot satisfy the 15 years. It was not part of the deed because it's never been part of the deed except for those properties west of the Lampkins. This part of Island Shore Drive was not part of these deeds. So the only way to get this right is through some other property right. So they can't establish the 15 years on their own. So they had to look back to the Gosses, their predecessors in interest, who were the ones who sold them the property under that contract. Now, it's undisputed that the Gosses had the property, owned the property, going back to the trial kept focusing around, that 1960 date. Even that was a little bit vague, it was the 1960s. But they had two of the Goss family testify that, we would go up, we would go to the property, and we would use Island Shore Drive. the problem that they have is that the only specific time they have to prove, it's their burden to prove by clear and cogent evidence, which is more than a preponderance. They have to prove these 15 years of, again, open, notorious, adverse, continuous use. And the closest that they get to a clear dates was the statement by Mr. Goss that the family he started going there when he was 6 years old, 2 to 8 times a year. And then out of high school, it dropped off. And he really just, as an adult, has not gone there. So you're looking at a period of 11 years that he established 2 to 8 years of using this Island Shore Drive to access this lot. And that's not enough. And they're several years too short. The Michigan case law has been clear that occasional periodic sort of use of a property is not sufficient for adverse possession or prescriptive easements. You get that all the way going back to 1930 with 251 Mich 175. It's Doctor versus Turner. You have Ennis versus Stanley 346 Mich 296. Both of those cases say that. They say the sort of occasional use is not enough to establish that continuity of use. And all of these elements sort of fit together, Is it continuous? Is it visible or open? How can it be visible or open if you're doing it, a few times a year? And as to visibility and openness, there was no development on the property. We're talking about visits to the property for occasional picnics and camping, 50, 60 years ago, that then dropped off before the statutory 15-year period. And they can't establish it. There are other, obviously this property and this driveway, or not driveway, but the roadway, essentially it is sort of a driveway, have been the source of other litigation in this court with other parties. And if you even look back at, for instance, this court dealt with my clients and other defendants in Lampkin versus Hartmeyer, which was, I think, February of last year. It was a second decision in the case. And the point of it is, that case doesn't control this case, because they were different parties, different interests. But there's some similarities. And when you look at what this court did in that case, it went through every defendant. It went through each one. It said, okay, for your parcel, can you establish this easement? Okay, for the next one, can you establish this easement? Because everyone is individual here. Yes, there was testimony that people use this road, and yes, people do use the road, but that the right that we're talking about is specific to this parcel, and as for the Lampkin, that's what's going on here. So the Gosses can't. I'm sorry, the Smiths can't just sort of piggyback on the fact that other people have established it. They need to establish it in their own right, and they have it. I'd be happy to take any questions that your honors have.
Any questions for Mr. Skinner? I don't. No, I don't think we have any for you. You will have time for a rebuttal.
Thank you, your honor.
Mr. Howell.
Counsel is correct.
We need your appearance.
Pardon?
We need your
Oh,
appearance.
Thomas Holm appearing on behalf of the Smiths, the appellees. Counsel is correct in indicating there have been prior cases
You could say that.
brought before the Court of Appeals, and as of February of 2024, there was an opinion in the Lampkin versus Hartmeyer case, which discussed Island Shore Drive usage among all of the section property owners, whether they were in section 21, which is what the Lampkin's in, or in section 22, which is above my client. And my client's property sits in between the two sections. In the court's opinion, in Lampkin versus Hartmeyer, they looked at all the evidence and said, at least since the 1960s and possibly from the late 1940s, that all the subdivision lot owners used Island Shore Drive, including that section through the Lampkin's property, in an open, notorious, adverse, continuous manner. From M36 all the way back to section 22. And the court then held that before the Lampkins acquired their property, which was in 1980, the first parcel, that this ingress and egress route had already been well established for at least 20 years, and certainly in excess of 15 years, which Lampkins have conceded. They've admitted that. So now take it to the present case. Nobody testified for the Lampkins except themselves. We produced the Gosses, a brother and sister who inherited the property from their parents, who their parents inherited from the developer, Douglas Golden. Douglas Golden was a developer back in the 1940s, building cottages and cabins. He used all of Island Shore Drive, including that portion through the Lampkins property, to haul his materials. There were construction trucks, and developing the parcels. In the 1960s, then his kids took over. There was some further splitting of property up there. Sally Goss acquired some property from her father, Mr. Golden. And then Sally split it. And what's real interesting in this quick case is the survey that was done in that case referenced the historical use of Island Shore Drive, which ran over the Lampkins property and went right through the Goss's property. Now, part of that property is owned by my client. The other part is owned by Virginia Sites. And there had never been any non-usage of that to get to the Sites property or to get to the Goss's property. And Sites had a cottage on her property. So this property from the Boston Engineering Survey shows the traverse way of Island Shore Drive as traveled right straight through the middle of my client's property.
The Sites were defendants in the Lampkin v. Hartmeyer litigation, were they not?
That's correct.
Yeah.
Yeah, that's correct. And the deed that my clients, the Smiths, obtained made reference to Island Shore Drive. It didn't say it included it, but it made reference in the legal description indicating the parcel travels along Island Shore Drive. And it was referenced and it was surveyed as their way from M36 to get to the property. There's no question when this was recorded of record that the Lampkins would at least had public knowledge, of that route that was taken. And the Gosses, when they testified, they were basically picking up from what their parents had done in the 60s, what their grandfather had done in the 40s. And if you look at the time frame, we have at least 20 years from 1960 to 1980 when the Lampkins purchased their property. But then there was a special assessment district which was petitioned for. It was in existence in 1979 before the Lampkins came in, and then it kept going for 3 decades, and that was basically on the Lampkins' own petition to keep that going. And so it was maintained and serviced Island Shore Drive. The Smiths, when they closed on their purchase,
they assumed those assessments. They agreed, okay, we're using Island Shore Drive, that's our way, we'll pay the taxes on it and assessments. And it took 3 decades to do that. So we have various points that we could go from who did what on that Island Shore Drive, but it's clear that there's more than 15 consecutive years that was used of the property that went through the Lampkins parcel. There was never any agreement with the Lampkins and the Smiths and otherwise to show that there was some permissive usage of that.
Anything but, it would seem to me, given the history of litigation and other related activities undertaken by the land.
That's correct. They were always looked at as trespassers of some sort or providing a nuisance of some sort, but there was certainly no agreement between them or permissive use, and that's why we're here today. If there had been some sort of a permissive use, it would have changed things, obviously.
Yeah, I consider it laughable to contend that this was permissive in any way, given the litigation history.
Yes, I mean, the adversity basically means that you're doing something without the need to ask or to accept permission. So,
Well, and I mean, nobody's mentioned maybe the most critical point on appeal. And your opposing counsel indicated that at the trial court level, your clients had to come forward with clear and cogent evidence for this permissive easement. But on appeal, we're looking at the trial judge's factual findings for clear error, which is a very high bar for the plaintiffs to hurdle here. So, you know, is there any question in your mind? Is there any weaknesses in the trial judge's factual findings that you think you need to shore up?
I don't believe so. Judge Hattie in this case, I thought he did an admirable job of handling this case. I mean, there was a number of motions made to disqualify him, and he bent over backwards to allow what evidence he could allow in, to allow all the parties to speak. He controlled his court rule in a good manner. There's no question on that. He also had the benefit of the case of the Supreme Court in the Marlatt auto case to determine the prescriptive easement elements, how do they fit? And he looked at each parcel owner out there as to how that would fit in the scheme. And so he's had a lot of experience looking at the law, and he did apply the facts to the law, in my opinion.
And if I understand Marlette correctly, your clients would not even have to tack on to the Gosses if the prescriptive easement was established by the Gosses, because then it runs with the land.
It becomes appurtenant to the land and it's automatically transferred without the need to go through the whole procedure and establish in 15 years under your own title.
Right.
You don't even have to tack on at
Right.
that point.
Well, and you mentioned the disqualification motions below. So there was a claim, or there is a claim on appeal that if it were to go back down, go to a different judge. I presume that is now moot because Judge Hattie has stepped down. He retired. So on that issue, do you have any is there any question that it's moot?
He is a visiting judge still. He does handle.
Does he do visiting work in Livingston County?
That I'm not sure.
I don't think.
I'm not sure you'd get him to volunteer for this case again.
You're probably correct. I've seen him up in Genesee County and other counties, but not really in Livingston County. But I don't have any further argument unless
Any
the court
questions?
has any questions.
Mr. Helm, I think we understand. Thank you very much. Mr. Skinner, any rebuttal?
Yeah, just a few points, Your Honors. So, you know, Mary Ann was, you know, pretty clear in her testimony that this was, it was not a problem until the traffic exceeded the scope of ingress and egress. I mean, that has been the Lambkin's main contention here. So I just want to, you know, make clear that it's not the adversarial problem that's been going on here is really about, well, partly about what is the scope of the right here. Now that's globally as to everybody. That's what's going on here. Is it for ingress and egress, or is it also for snowmobiling? And all these other things that were going on. Part of the issue here is that one of the questions is, the question is the prescriptive easement the correct solution? So there's a lot of evidence, and it's undisputed. Island Shore Drive is there. People were using it. One thing I want to point out is what I said before, is that this is specific to each parcel. Number two, it's also important, as when you read these real property cases, 800 years of common law, what specific right are we talking about? So for instance, I apologize, one of your honors asked about, the tacking and the Gosses. Right. It's true. If the Gosses had established a prescriptive easement, it would run with the land. But if it's an easement by necessity for ingress and egress, those are different things, and they have different scopes. And for instance, ingress and egress, easement by necessity, can be terminated. Prescriptive easement cannot. As you said, it runs with the land. So it's important that it be done properly, so that the landowners, the dominant estate's rights can be vindicated. So that if, for instance, there were a new path to the road, to the parcel, that could terminate if we're talking about an ingress and egress easement by necessity, as opposed to a prescriptive easement. So no, it's not prescriptive easement. That doesn't mean that there isn't some solution here, or that there isn't possibility for ingress and egress. And again, the Lampkin said we didn't have a problem with that. What we had a problem with was, the lumber trucks going up and down, and all these other difficulties that were beyond just necessary ingress and egress. And otherwise, if your honors have any questions, I'd be happy to take them.
Any other questions? All right. Thank you very much. We appreciate your arguments. Thank you for appearing.
Thank you, Your Honor.
Submitted. Thank you. Okay, that brings us to item number 8, docket number 369599, Douglas R. Merrick versus Kristen M. Merrick. And Attorney Bassett will be appearing via Zoom. Mr. Gentry is here at the podium, so let's give Mr. Bassett a moment to materialize. Okay, and there he is in his familiar surroundings. You might want to consider a new backdrop there, Mr. Bassett. I don't know. But it looks very nice. I will say that much.
Yeah, it's kind of like something from the Mad Men.
You're right. Exactly. That's very apt. Mr. Gentry, give us your appearance and you can proceed.
Good afternoon, Your Honors. Kevin Gentry on behalf of the defendant appellee. Your Honors, Mr. Bassett is right about one thing. I'm stuck with the case that was presented by my client. And my client makes $22,000 a year, and on page 16 of the judgment awarded her no attorney fees. His client buys helicopters for fun. So I was under a little bit of a disadvantage. So I took 2 issues that relied on his client's testimony, which the court found credible, one of them, and the other that relied on his client's own appraisal. His client's own appraisal on Washington Square was $231,605. Take off some self-dealing loans, which you can, $185,405. Trial court comes to 0. And then Web Local has $340,000 in cash. in the bank. They say that's left over from an SBA loan. Maybe it is, maybe it isn't. But Web Local makes some money, enough money to buy helicopters. And we know from Kowalski, we know from a number of cases that if it's a going entity that makes you money off of what's in your head, it has value. It's a professional entity. It has value. If you're making money off of something, I use the simple example of a car that was over in debt, an upside down car. That's fine. It's not worth anything in a divorce. But if you're using it to make an Uber money and you're making $156,000 a year and you're not paying it off to keep the tax man happy, that's got to be worth something. And that's basically our position here, is that he's making six figures in money. And the trial court awarded basically nothing, actually flat out zeros, for Web Local, for Washington Square, for Marico, for all of his businesses, based on what I got to say is a really good trial brief by his counsel. That said, even though our appraisal said, hey, Washington Square 246, trust us is zero. Very tough. Thank you, Your Honors.
All right, any questions for Mr. Gentry before you get away? No, okay. Mr. Bassett?
Scott Bassett appearing for the appellee Douglas Merrick. One of the problems that, as Mr. Gentry acknowledged, is that there was very little evidence to challenge, really no evidence to challenge the testimony that was presented by my client or was admitted by stipulation in the expert valuations of his business or of the building. If you expect the trial court to accept your values over the other side's values, there are some things you have to do that weren't done here. Mr. Bean conducted the valuation of Web Local, and he valued it as a going concern. He valued it as businesses are typically valued in divorce cases. He took a look at the debt. He took a look at the assets. He took a look at the income. I mean, my client does not earn a six-figure income. As I've indicated in the brief and as the record showed, he averaged $67,000 per year over the 3-year period leading up to the divorce. Mr. Bean took all of that into consideration and assessed that the value of Web Local was zero because its debts exceeded by about $2,000 its assets. There was no contrary evidence. In fact, in the defendant's testimony, she could have challenged any of that and didn't do it. In fact, Web Local is not mentioned even once during her testimony. And what her counsel could have done is called Mr. Bean to be cross-examined, didn't do that, could have presented another expert to present an alternate view of value, didn't do that either. There simply wasn't anything on which this judge could have come to any conclusion other than the one it did, which is that Web Local had no value. It's like a lot of other businesses, it was highly leveraged. It's a simple question of, assets minus debts equal value. We had a similar thing with the office building with Washington Square. That was valued by an appraiser. Again, the defendant testified and never mentioned Washington Square, never challenged its value, never brought in her own appraiser, didn't subpoena and cross-examine the appraiser of the building. Now, Mr. Gentry is nominally correct in that the appraisal would have suggested approximately $130,000 of equity in that building. But as the judge found, my client credibly testified that there were other factors that needed to be taken into consideration that the appraiser didn't clearly address, one of which was probably the most important. The primary retail tenant on the ground floor of that building was a Subway shop, and Subway canceled its lease and left. When you lose your primary retail tenant, that's a significant drop in the value of the real estate involved. Another thing that, of course, needs to be taken into account whenever you're talking about possibly selling a building is the cost of sale. Commercial real estate commissions typically run in the Lansing area 5 to 6%. So that would have eaten up about $70,000 of this alleged $130,000 equity. And the rest, I think you can take into account in the loss of the primary tenant and just the general conditions. I mean, my client was unfortunate enough to close on this purchase of the building like 3 or 4 days before the president declared the national state of emergency during the COVID pandemic. You know, the goal was to bring in the people who worked for him in Web Local and have them work in the office. Well, the pandemic made that impossible. So the building was never able to be put to the use that it was intended. So when the judge said, you know, I agree with the plaintiff's testimony that there isn't any value in this building, there was really no contrary evidence that would have allowed the judge to come to any other conclusion. So this is simply a case where there wasn't any evidence to allow the judge to come to conclusions other than what she came to. You know, she reviewed the evidence, found my client's testimony very credible, and found, well, she talked about the defendant presenting testimony that was speculative on value. In fact, the defendant didn't present any testimony on value. I think what she was really referring to was the closing argument that was presented by defendant's counsel, where there was argument made as to value. But this was not a case where, you know, a brilliant trial brief won the case for my client. The trial brief was very good, but all it did was note that all of these values were effectively undisputed. So the judge went with the undisputed values. So we're asking the trial court be affirmed.
Any questions for Mr. Bassett? All right. Thank you very much. Mr. Gentry.
As I will give the other side that they have a good valuator and really good accountants. To keep them that upside down for tax purposes for that long is brilliant. He makes $60,000 a year. He spent 80 undisputed on helicopters. He makes $60,000 a year. The SBA gave him $500,000. He makes $60,000 a year. He bought Washington Square for $1.2 million. Your Honor, he may have really good accountants, but if those numbers are correct, his bankers are drunk. And the reality of the situation is this court is required to look at whether or not the disposition was equitable and fair on all the facts in the record. And the facts of the record here are not very well presented, but just what the plaintiff presented doesn't make fair and equitable. Thank you, Your Honors.
All right. Thank you very much. We appreciate your arguments and the case is submitted. All right. That brings us to our last item of our case call, item 9, docket number 368595, Rose Stevens versus Estate of Brittany Hunter. Are they listed? Ah, they are. Okay. And docket numbers, thank you, Judge Boonstra, 368596 and docket number 368622. All right. We have 3 lawyers at appellant's counsel table. Ms. Whitman flying solo for appellee. Gentlemen, I assume you've discussed how you're going to divide your time. You have 30 minutes among you, inclusive of rebuttal. So I'll just leave it to you to argue it as you wish.
Good afternoon, Your Honors. Sean Friel appearing on behalf of the defendant appellant, the state of Brittany Hunter.
Oh, you're here in person. I thought you were going to be zooming in.
I did request to appear by Zoom. I work in a small firm, so I have to keep my options open, but I'm glad to have made it today.
Good.
So I represent the estate of Brittany Hunter. She's passed away since this incident occurred. She is alleged to be the operator of a motor vehicle involved in a hit and run accident that injured the plaintiff, Rose Stevens. She moved for summary disposition in the trial court on the issue of factual causation, arguing that the plaintiff is unable to create a genuine issue of material fact under C-10, much less meet a burden of proof at trial that Brittany Hunter was the operator of the vehicle involved in this incident. The court denied that motion, and we've appealed. The crux of the argument was that plaintiff's theory is speculative. And for example, in the underlying motion and in the appellate brief, they focus on witness statements from a boyfriend and a brother that say everybody, including Brittany on occasion, would operate her mother's vehicle under certain circumstances. That general statement doesn't get anybody to a specific date, time, or place when Brittany Hunter was operating it, as alleged by the plaintiff, involved in this hit and run. When the officers found this vehicle, which the defendants don't concede was even involved to begin with, but for sake of argument, when the vehicle was found, the investigating officer noted that the seat was close to the steering wheel, in her belief suggesting that maybe somebody of a smaller stature might have been driving it.
The vehicle was found 3 days after the incident, wasn't it?
I believe so, yes, Your Honor. 3 days later, the officer says the seat's in the position suggesting maybe somebody of a smaller stature was sitting in it. That's speculative itself, but to say that I don't believe there's any evidence in the record that Brittany Hunter is of a smaller stature or that the owner of the vehicle isn't of a smaller stature. There was a lottery ticket. Plaintiff relied on the fact that a lottery ticket was found in the back seat of this car and had been scanned on a mobile device registered to Brittany Hunter sometime before the accident occurred.
20 hours, I think.
20 hours before. At best, I mean, that lends itself to an equal possibility that Brittany Hunter was in the back seat of this car. Doesn't put her in the front seat, doesn't put her in the driver's seat, much less at the date, time, and place of this accident. It's possible, but that's the whole argument here, is that their whole case is based on nothing but possibility. Another piece of evidence that they relied on was that she refused an interview with the police at a time that she was not either detained or under arrest. She could have chose to not spoke to police for any reason or no reason at all. She has a checkered past. It could be possible, and I think the plaintiff will even concede this, or already has in its brief, that her boyfriend, Mitch Huggard, could have been one of the drivers. It's possible that she chose not to speak with police because she didn't want to implicate her boyfriend in this hit and run. Again, all possibilities. When the police went to get an arrest warrant, it was denied for lack of probable cause. And finally, DNA evidence from the steering wheel came back being positive from multiple contributors, including at least one male. These facts, you can't deduce from them any permissible inference, reasonable inference, or logical deduction that Brittany Hunter was driving at the date, time, and place of the accident. It's speculative at best. I think the trial court respectfully had it wrong when it said the specter of criminal charges and credibility issues with the mother creates a genuine issue of fact that her daughter may have been operating her vehicle involved in this hit and run incident.
It's an issue of fact, but is it a genuine issue of material fact where there's evidence on the other side of your argument, I guess is the question.
Not a genuine issue, and the Seminole case, and I don't need to go through any of that, Skinner says you can't move on speculation alone. And none of these facts, all these facts together, I mean, you could say, well, how much circumstantial evidence do you need? These facts, when you consider them together, actually broaden the scope of possibilities. It implicates multiple other potential drivers. These witness statements that everybody would drive it. The seat position doesn't prove anything about who was driving. The lottery ticket, the fact that she didn't want to talk to police. None of these actually put her behind the wheel. You can't draw a conclusion to the exclusion of all these other possibilities. So we believe the trial court had it wrong. We're asking that it be reversed. Thank you.
Co-counsel arguing? Okay.
Good afternoon, Your Honors. Clayton Meter appearing today on behalf of defendant appellant Kimberly Hunter. I'd like to just take a minute and let the court know I appreciate being able to appear in person. I know we were scheduled to appear via Zoom, but I got the opportunity to present this argument 8 days ago, I think, when I got my P number. So tomorrow I'll be celebrating 3 weeks as a member of the Michigan State Bar.
Congratulations.
Congratulations.
It really is my pleasure to be here in person and get the full experience.
Pretty quick to be arguing your first case in the Court of
Yeah.
Appeals.
Right. I'm very fortunate where I work to be put in the position where I can go out and develop some chops, which this is my second rodeo. I appeared on Monday in district court, so I'm not completely green.
We'll be gentle.
Maybe.
Anyways, so the question raised by our application for leave to appeal is whether the circuit court erred in denying Ms. Hunter's motion for summary disposition pursuant to MCR 2.116 C10. In response to this question, we would answer yes, the circuit court certainly did err. There's no reason for Ms. Hunter to be involved in this action today. She was named on a single count of vicarious liability pursuant to the Michigan Owner's Liability Statute. But however, the statute doesn't apply to Ms. Hunter, as plaintiff has offered no substantively admissible evidence establishing that it was Ms. Hunter's car that was involved in the motor vehicle accident. Moreover, nobody can identify the driver of the vehicle that struck plaintiff, and there's no evidence that Brittany Hunter had the express or implied consent of Ms. Hunter to operate the car on the date of the accident.
What about the fact that there was damage to Ms. Hunter's vehicle that certainly was consistent with the accident? And there were parts, I think, in the road where the accident took place that suggest that it's at least this, those parts came from the same make and model of your client's vehicle. And your client lives in the same general area. It's not like, that we're talking about hundreds of miles away. So you put the proximity, the consistent damage, and the fact that there were parts that certainly tied to the make and model of your client's vehicle. Why isn't that enough to at least get over summary disposition?
Well, Your Honor, if we're relying on the fact that I think that they only, Corporal Pashek, who investigated the incident, she testified that they only matched up this driver's side mirror that was found at the debris field to our vehicle when it was found. If we're relying on the UD10 traffic crash report, you'll see within the narrative section that Ms. Hunter's son, Mark Bryan, comes out of the house and he says, well, yeah, the motor vehicle was also involved in an accident in Saginaw County in December 2020. So only 3 months prior to the incident that we were alleged to have been involved in our vehicle. So I think that
But then when your client was deposed, she gave, if I remember correctly, and I'm paraphrasing, she just didn't remember. I don't know how this happened, an accident somewhere, somehow, at some point. I mean, as the owner of a vehicle, you'd think she would have a little bit better understanding if it had happened earlier, when and how did this specifically happen?
Well, she also testified at the same time that she was unaware that the vehicle was even suspected of being involved in a motor vehicle accident until moments before her car was being towed away, as evidenced by Bay County Police Department. So I think it cuts in both directions. She's unaware that the vehicle or how the damage got there, but she must have certainly in the 3 days went out there and looked at her car. And
I guess the way that I would look at it is clearly someone, I presume, would have prepped her for her deposition. And presumably she would have said, yeah, I was involved in an accident, but it was 3 months before this issue. And presumably there would have been a conversation. Hey, that's really good for your side. Do you remember when it happened, where it happened? And so if your argument is accurate, you would have thought her deposition would have been a little clearer on this issue. Because if that car had gotten damaged 3 months prior and they have any kind of solid evidence of that, that's really good for your client. And I'm just surprised that your client didn't have a better memory about that earlier accident if it actually did occur. And there was no question at the end of that. I'm just up here,
okay,
opining. So, but that's, I think, from my perspective, that's one of the weakest parts of your argument, because there was consistent damage to the vehicle.
well, certainly, but anyone that's drove around Saginaw County in December understands that you're coming into contact with deer that are certainly crossing the road all the time. And You know, if I recall, she admits that there's damage to the front end of the vehicle, there's damage to the back end of the vehicle. So it sounds like the vehicle wasn't in pristine condition as it sat there in the interim in those 3 days. And still we're speculating. There hasn't been any positive evidence that links our vehicle to the accident or places it at the scene of the accident, let alone identifies the driver of that vehicle if it really was involved. One of the stronger pieces of evidence here is that there is, you know, one set of car keys for the vehicle. Ms. Hunter went to bed that night at roughly 8 o'clock. She puts the one set of keys to the vehicle in her purse and takes her purse to bed with her. Her vehicle is parked across the street at the church parking lot. And when she wakes up the next morning, the keys are where she left them and the vehicle is in the same spot. And like,
I'll be honest, when I read that, it struck me as odd that someone would sleep with their car keys. It's very convenient for your client. Is it because the daughter who passed away had some problems with the law and clearly had some substance abuse issues? Is that why your client went to these extra steps of securing?
not to speculate as to what or why, but I would imagine that that's certainly part of it. Ms. Hunter says that Brittany from time to time would stay at her house. She's not sure if she was there on the night of March 20th at the house, but you know, I'm sure she got in the habit of making sure that the keys were with her.
Was there any deposition testimony on this? I mean, I don't want to speculate too much, but do you recall?
I don't recall.
Okay.
But if you read through the testimony that she gives, she would give permission to Brittany from time to time, but it would be fair to classify the permission that she gave her as case by case, transactional. She looked at Brittany and made a clear judgment as to whether or not she felt comfortable giving her the car. And the facts indicate that, you know, Brittany had never asked, I don't believe that, to use the car that night because she took the keys with her and took them to bed with her. And like I said, Ms. Hunter said that she was unaware of any damage to the vehicle until it was being towed away several days later. And it's certainly a quantum leap to go from all these possibilities that we've discussed to infer that there was implied permission and that it was our vehicle that was involved in the motor vehicle accident.
The client's testimony was sort of, I think, implied the opposite of a general permission to drive the car, because didn't your client testify that Brittany drove the car occasionally and only with her Kimberly's explicit permission? Do I have that correct?
That is correct, Your Honor.
Was that her testimony?
Yeah, and it didn't sound like she had allowed her to use the vehicle all that frequently. It was just a couple times here and there. So there wasn't like this pattern of practice where she was giving her the car all the time. It was a judgment call on a few instances where Brittany used the motor vehicle.
Anything else for us?
No, Your Honors. I will otherwise rely on our submissions and thank you.
Thank you. Counsel?
Good afternoon, Your Honors. Joseph Fazzi on behalf of the Appellant Homeowners Insurance Company. I have the deck action here in this case, and I will say that I know you've read all the briefs, but one thing that I appreciate here today that didn't occur in the trial court was that the underlying case went first here today with the alleged at-fault driver, excuse me, and the alleged vehicle owner presenting their arguments. And I do think that's the proper way to handle this here, because with a declaratory action like this, there are issues that have to be resolved in the underlying case, or that have to come out in the underlying case in order to have the deck action come to a resolution. The arguments we're making here are twofold. One was that Brittany Hunter was a non-permissive user of the vehicle based upon the testimony of Kimberly Hunter, as was just articulated by Brother Counsel. And second, that Kimberly Hunter was non-cooperative in her investigation of this claim, and therefore it's a separate basis for homeowners to disclaim coverage here. I'm going to keep it very...
Didn't you also disclaim coverage by the fact that, or, you know, the arguments made that there's no evidence tying Kimberly or the daughter, Kimberly or the mother, Kimberly or Brittany, to the vehicle or to the accident?
I can't say that. That's where it gets tricky. And this is why I say this. if this panel reverses the trial court as it relates to the underlying case, my entire case is moot at that point because they are out of the
That's
case.
my point.
There's no controversy then for me to even have a declaratory action on. I'm not going to say that it eliminates coverage, 'cause I don't think that's the proper way to say it, but I think it makes it moot. So if you reverse on the
Well, it
underlying.
means that Kimberly, your insured, can't be liable, which is what the policy language is.
Exactly. So that there's no duty at that point. She does not have an obligation to the underlying plaintiff. There is no indemnity that we would owe on her behalf. Our duty to defend, we have been defending in the underlying case. We did a hire defense counsel for them in the underlying case. This declaratory action obviously seeks to end that. But you're right. If you reverse the underlying case, my case is moot. But going to just briefly the facts with Kimberly Hunter, her testimony, I think, is clear here. She did not give permission, number one, to Brittany, number two, to anyone else to drive the vehicle that night. So if the car was involved in the accident, it was used without permission. Number two, regarding the damage that Your Honor brought up in parts at the scene, I believe there's testimony from either the investigating officer or the husband of the underlying plaintiff that they did the Google search to find out about the parts. And one
The
said.
parts are consistent with, but they're not, it's not like they have VIN numbers that match or anything.
Correct. There's no VIN numbers. There's nothing like that. But I also believe that the husband testified in the underlying case that he did a Google search and it came back as being parts of a Mini Cooper, which then that's not consistent with the vehicle being involved. It's just consistent with a car in general. So I do think the testimony is clear here. It's unequivocal that there was no permissive use. I do think the trial court erred in assessing or trying to impute there's an issue of credibility here when there's no contradictory admissible evidence to even support that. Because if the standard was that the court could say there's a credibility issue with any witness or any person's testimony in any motion for summary disposition, no motion for summary disposition could ever be granted or could even proceed because the court could automatically question the credibility when we don't have an issue of fact. We don't have a he said, she said situation. So that's it on the Kimberly, the non-permissive use issue. On the non-cooperation issue, the accident allegedly happened March 20th of 2021. It wasn't reported to auto owners until May 3rd of 2021. Auto owners sent letters to Kimberly Hunter, May 14th, June 24th, July 15th. Kimberly Hunter testified in her deposition that she had a whole stack of letters from auto owners that she didn't do anything with. Auto owners was trying to investigate this case.
She testified to a phone call with homeowners. Do you have any record of that phone call occurring? Does your client have any record, I should say?
I would say if the phone call occurred, it would be documented. I don't have that information off the top of my head to tell you one way or the other, but I know that just because a phone call occurs doesn't mean all the information is obtained.
Well, but I mean, that's the flip side of your argument. She testified that she spoke to someone on the phone from your client.
Right.
You don't have any evidence to suggest she's wrong. And so that's the only piece of evidence in this case is that she talked to someone from your client. So
I'm not going to rebut and say she didn't talk to them. I'm not going to say that auto owners didn't talk to them on that, or excuse me, homeowners. I apologize for
And she sat for a deposition.
She did sit for a deposition 20 months approximately, or 22 months, I believe, after the accident, 20 months approximately after the claim was turned in to homeowners.
But did homeowners try to get the deposition moved up, do it much more quickly? Or was homeowners more than happy to allow the time to tick?
This is what I would say with that. The deposition was scheduled with the underlying case. Homeowners appeared on behalf of in this deck action. Our office was involved in this case. I can tell you that there were attempts to try and do an EUO, but at that point, the litigation had been filed by the underlying plaintiff. So it's the situation where we wanted to get more information. The situation where letters were sent by the claim rep as documented that Ms. Hunter said she didn't respond to. And it's also a situation where had we had the information that Brittany was the driver, and I'm not saying she is, but that's the allegation in the underlying case. Had we had that information, more could have been done, especially in light of the fact that no one knew Brittany was going to pass. but she did. And there would have been an opportunity there for an investigation to occur, and it didn't because of non-cooperation on the part of Kimberly Hunter. And I wanted to stress that the cooperation doesn't only fall in the context of litigation, it also falls in the context of investigation of a claim, which is what we have here on the declaratory action end, investigating the claim before the litigation is filed, and that's where we are hampered. If your honors have additional questions for me, I'll be glad to address those at this time, but I would like a couple minutes in rebuttal. I think we have a little time.
One question before you sit down. I'm glad you distinguished between the duty to indemnify and the duty to defend. Your brief, however, argues that there's no duty to defend where no coverage exists under the policy. I guess I'm wondering, do you concede that the duty to defend is broader than the duty to indemnify and that you properly defended in this case?
I would say this. The duty to defend is definitely broader than the duty to indemnify. There is no question about that. Defense counsel was hired for both the estate of Brittany Hunter and for Kimberly Hunter. I would say to the extent that there's non-permissive use by Brittany Hunter or by anyone else, there is no duty to defend there because it's the same scenario as if the car had been stolen, taken by anyone else. I'm assuming your honors have your car keys in your pockets, but if they were left on the bench and I were to walk up, grab your car keys, walk outside, find your car and drive away and get in an accident, there's no permissive use there. And your insurance company, if you get sued because the accident's my fault, I'm saying I'm a good driver, but this is a hypothetical, they wouldn't have a duty to defend me for that because the vehicle was taken without permission. And that's where we're getting with this case, with the argument in the brief. And I hope that addresses your honor's question. You're welcome.
Thank you. Ms. Whitman.
Afternoon, Beth Whitman appearing on behalf of the plaintiff. So there's multiple issues in this case, but there's with respect to whether the car was involved, whether Brittany was driving, and whether there was permission for her to drive in any way, shape, or form. So, okay, I think I agree with you, Judge Schwartzel. I think the car being involved, I think that's a much easier issue to deal with first off, because we've got an entire police report. And this is by far the most comprehensive police report I have ever seen in my entire practice. I think it's 200 and some pages long. Not only were there parts that were found that were consistent with an HHR vehicle, there was also witness testimony saying that they saw a dark colored HHR vehicle that went screaming south right after this event that took place. And the officer that had this case said these parts matched the void that was in Ms. Hunter's vehicle, in Kimberly's vehicle. I'm going to refer to them by their first names just so there's not any confusion. Okay, so it's not just that, this might be parts to, another type of car or whatever. These were the parts. This is what the police actually, after this very, very thorough investigation, determined this is the car. This is the car that was actually involved here. And we're not talking just a little bit of damage. We're talking the front end is completely smashed in. The mirror on the side is smashed in. I mean, this is a significant accident. These are significant injuries that occurred to my client as a result of this.
At least there's evidence in the record
There
from
is.
which a jury could conclude that it was this vehicle.
That is exactly it. Okay, so next step. Is it Brittany that's driving at that point? Okay, so we know, what do we know about her driving? So we know that the officers, again, in this very, very comprehensive report that they have done, they come down to 2 drivers. And this is based upon witnesses that they've talked to who have indicated, you know what, we think it was Brittany was driving and she's going to let her boyfriend take the fall, Mitchell. There was no, under any circumstances, there was no investigation as to some sort of other driver. There was no indication that this car had been stolen. It was never reported as stolen. Kimberly never indicated that it was stolen or her keys were missing from her purse or anything else. This car, clearly, it was the one that was involved, and these 2 individuals are clearly the ones that were involved in this accident.
Why couldn't it have been Kimberly? She owned the
It,
car.
Just
it
about.
could have been Kimberly. And if
Okay.
if there's a question of fact as well as to whether it's Kimberly, then that should go back as well.
Well, the point is, you have a summary disposition
That is correct. Yes.
motion here, which
Yes.
means to survive that, you have to have some evidence.
Yes.
That's enough from which a jury could conclude, right, that it was Brittany. So
Sure.
what evidence is there? Evidence
The
in
evidence.
the record that Brittany was driving.
And we also know too that Brittany was allowed to use the vehicle, as back and forth
With
as.
express permission. I think that leads to the opposite inference
And
than the one
it's-
you suggest.
And I know you indicated that before too. So I was looking at, what Kimberly actually said.
Yeah.
And there was a back and forth that said, what, did you have a policy of where she was not allowed to use the vehicle that you told her about? She said, yes. And then the follow-up question is, so is it your testimony that she was never allowed to drive your HHR? And the answer was, I gotta make it bigger, unless I felt comfortable with it. I can't say never let her use it. Excuse me. I can't say that I never let her use it. I mean, I can't say I never ever did. And then he said, do you know or do you not know if that vehicle was used by Brittany on March 20th of 2021? I don't know that.
Well, she can't know that.
She can't
She
know
was
that.
asleep.
But, well, that's what her testimony was, but her testimony is also, and I think, you made the point, Judge Swartzel, too. Her whole testimony is very, very convenient. She says, I was asleep at 8:00. Well, this accident happened at 11 p.m. So, she could have been sound asleep and somebody could have come in and taken the keys from her purse if they were assuming that purse was actually in the room. The other completely incredible thing in her testimony, in my opinion, is she says, I never asked Brittany if she was involved in this accident. I never asked her if she was driving my car that time. If my car was impounded, I think if anybody's car was impounded and there is a question of who perhaps may have been driving it that was involved in an accident, you better bet that any reasonable person is going to have that conversation with their child. So
Maybe, but again, and I indicated that I thought it was really odd that she
Yes.
would put keys in a purse.
in
and
a
go to bed
purse
with the
in her
purse.
room.
But if you have a child who has had some significant problems, drug problems, I mean, we can all imagine.
You can imagine,
What
yes.
what she went through. And it would, it's entirely possible that Kimberly said, I'm not going to ask the question because I don't want to know the answer.
And that could be, but that testimony isn't here. That was
That's the
never.
problem.
Yeah.
I mean, again, I could see where you might be able to get that the car was involved.
Mhm.
I mean, it's thin, but it's there. But I mean, there's just no evidence of who was driving. I mean,
But again, the police came to the conclusion that it was in fact either Mitchell or Brittany, and they determined it was Brittany.
But
I
the
mean,
prosecutor wouldn't charge.
that is true, but the prosecutor has to prove something beyond a reasonable doubt. So that's the problem here, is that I don't have to prove anything beyond a reasonable doubt.
I mean, police say a lot of things.
They do,
Not sure it's
certainly, but
accurate to say, is it that the police determined that it was her?
yes, I think so. They sent a warrant request saying Brittany was the driver, Mitchell was in the car with her, because they put him as kind of like an accomplice, I think, in the
I
warrant
don't know what
request.
evidence there would be that he was in the car with her, but
I think based upon the witnesses that the police officers had met with, that said Brittany was the one driving, she and Mitchell were out, she's going to let Mitchell take the fall. So there certainly is evidence out there then this is all comes from the police. This is not, and trust me, I understand why maybe people would not trust the police, but this is the evidence that we have, and this is a very weird situation. This doesn't normally happen. But the other thing too, I think you have to also look, and this is the real point that I think the trial court made, you have to look at Kimberly's kind of, maybe she doesn't want to make these suggestions that her daughter might have actually been driving. There's potential criminal action that could arise from this. There's even potentially criminal action that could be taken against her if it ever were to come out that she did in fact know that Brittany was driving and caused that accident and didn't ever say anything.
do you need to identify who was driving if there's evidence that it was either Kimberly or Brittany with permission.
With permission. I don't, I think that's all I need.
It's Brittany without permission that would be problematic for you.
That could be problematic. I agree with you. We can, if it's okay, we can move now next to the permission.
Well, let me
Oh,
add
yeah,
one
please.
thing first, because I
Of
want to
course.
I want to go back and I'm sorry, I don't have the transcript of the deposition
Yes.
in front of me, but my understanding is that Corporal Pashak, I don't know how you pronounce her name, who
Yes.
investigated. this,
Yes.
testified at her deposition that the investigation had focused on Brittany and Huggard as potential drivers,
Mhm.
but that she was unable to form a conclusion regarding who was driving the car.
But it certainly, those were, again, I think my point is too, still that there is never any other driver that was ever looked
I
at.
understand, but I thought you said that that the police concluded that it was her.
Okay, so maybe not concluded, but this is what they presented. They presented that it was one of these two people and they believed.
Maybe the difference between a theory, that's their
sure.
theory, but a conclusion when she's asked at deposition and she's under
And
oath.
she's under oath and says, no, I can't say that she was, 100% the person that was the one that was driving. And again, I think we also have to keep in mind, again, the police officers, they are, again, dealing with a beyond a reasonable doubt standard that we don't have here in a tort action. So, could she say, saying I concluded or I absolutely knew? No, I don't think she could. But here, I think that the evidence taken as a whole, it gets me over that greater than 50% mark.
Yeah, I'm back looking at the evidence.
Yes.
I understand why you might question whether Kimberly was being truthful,
Absolutely.
but I'm still wondering what evidence there is in the record that Brittany was driving that doesn't require the jury to speculate.
Well, because again, we know that she was allowed to drive. Another point too, just looking at Kimberly's testimony here again this morning when I was going through it, she also indicated that Brittany's car prior to this accident had been sold. It had stopped working and it had been sold.
Brittany's car.
Brittany's car, yes. So if that's the case, then Brittany doesn't have a car. So is it likely then that she would be using her mother's car because she was allowed to use her mother's car? And that was consistent with the testimony from Mitch, or the statements from Mitch, the boyfriend, as well as the statements of the brother who indicated that, yeah, everybody uses the car, except me. I don't use the car. He did say that. So, okay. Let's see. I just want to make sure there's nothing else that I wanted to touch on with that. So with respect to the permission, again, and I don't think opposing counsel discussed this at all, but we're dealing with an implied consent under the Michigan Owner's Liability Statute. So that statute is very clear that there is in fact a presumption of knowledge and consent when it's a resident, for example, a daughter who is driving the vehicle. So what you have to have in order to get over that.
When it's a relative, which is defined as someone who lives with her.
No.
Isn't that right?
No, not in that statute. That statute, the presumption, if it's a family member.
I'm sorry, I'm thinking of the policy line.
The policy language, the relative, it does have to be somebody who resides there. That is correct. And again, resides is very different than domicile, and I'll go into that next. But no, it has to be, if it's a family member, then there is this presumption. And the only way that you get over that presumption is if you have positive, unequivocal, strong, and credible evidence that was not, that permissive implied consent was not given. And
Well, and was there any evidence to the car that was impounded that it was taken without permission in terms of the lock was jimmied or that somehow
it wasn't hot wired,
ignition-
right? Right, nothing like that. Nothing in the police report to say that there is
So
anything.
there's no indication that it was operated with anything other than
The sole
one
key, exactly, the sole key that Kimberly said that she had for this vehicle, exactly. So, there's certainly no evidence that Brittany was an excluded driver. There wasn't any testimony that there is some unequivocal testimony, I suppose, about whether or not she was ever told she couldn't take it or she could only take it under certain circumstances. But again, that testimony, I think, again, you got to take it with a grain of salt because this is somebody who has some incentive maybe to not maybe tell the exact truth as to what's going on and under these circumstances. You also, again, you know, same things. It wasn't ever reported as stolen. And, you know, the son even said, you know, everybody drives this car. So based upon that, I think there's at least a genuine issue of material fact as to consent. The fact that she said that she didn't give her explicit permission that night, that goes to the express consent under that statute. It doesn't go to the implied consent, which again, I think all of those facts go to an implied consent. Let's see. So again, what we're asking here again, it's a summary disposition. So we should take this to a jury. This should go in front of a jury and they can believe Kimberly. And if that's the case, then, you know, we lose. If they believe her, that's it. But if they don't, if they think that she's got a reason that she's maybe not telling all of the truth or she's evading the truth perhaps, then that would be something that I think gets us at least past summary disposition and gets us into a trial. With respect to the cooperation clause, again, I don't think there's any dispute on this, but Kimberly's cooperation or non-cooperation with her insurance company has no bearing on whether or not there is liability coverage for my client. I don't think that there's any dispute with that case. It's clearly established under the Coburn case, which is a Michigan Supreme Court case, that a non-cooperation isn't any basis to exclude liability coverage. So if it's just non-cooperation, my client is still going to be able to be entitled to get into that policy. Next, then we'd get into the policy, whether or not there is any other basis under the language of the policy. And that's where that policy language comes in. And I was going to pull that up as well, because there's four avenues for, or four sections in the coverage. There would be on your behalf, and your meaning Kimberly, on behalf of any relative using your automobile, and that would be Brittany. And 3, on behalf of any person using your automobile with your permission or that of a relative. Okay, so first of all, if it's your behalf, if Kimberly remains in this case, then obviously there's going to be coverage for her. If she's got liability under the owner's liability statute, then coverage would apply to her under that situation, under subsection 1. Under subsection 2, it has to be a relative, and relative, as Judge Boonstra, you indicated, has to be somebody who resides with you. There's all the factors that when you talk about residence, Brittany did in fact receive mail there. She would come and go according to Kimberly, and Kimberly even said, you know, at that time, she may have even been living with me. She may have even been back with me. She had an apartment somewhere, but I think, you know, it's possible she was back with me at that time. So that was her mailing address with her mother. Even on her license, it was her mother's address, even on her death
I
certificate.
think it's her domicile and her residence, so I think we can move on.
Okay,
from
okay,
that.
sounds good. And then, so if that's the case, then she would fall within that subsection 2, which is on behalf of a relative who's using the automobile. There's no provision in that subsection 2 that talks about the permissive use. It's only in subsection 3 if we have to get there, which I contend we don't have to, but it's only on that subsection 3 that the permissive use issue comes into play. And for all the reasons that I've indicated before, I think there is in fact permissive use. So does the court have any
Anything
other
else?
questions?
No.
Okay,
Very
fantastic.
well done.
I then will hopefully sit down because I think I have said everything that I needed to say. So, okay, thank
I
you
think
very
you have
much.
too.
Okay, good. I'm so glad. Okay, thank you again.
All right, rebuttal. Great.
The absence of evidence that Brittany Hunter was the driver does not lessen plaintiff's burden of proof when the probabilities are evenly balanced as between Mitch and Brittany
And Kimberly?
and anybody else. You direct a verdict for the defendant. And one thing I do agree with her on is that the 229-page investigative report was extensive. They did everything they could. And when Corporal Paschik was asked at her deposition, and did you ever make a determination to who was driving the HHR, or was it your determination that it could be either Mitch Huggard or Brittany Hunter? Her answer unequivocally was, I did not make a determination. That's all I have. Thank you.
Co-counsel?
I would just point out that there's no reason to call into question Ms. Hunter's testimony. It's been held, Creasure v. Duff, 331 Michigan 699, uncontradicted evidence given by the defendants alone is sufficient to rebut the presumption and justify a verdict for the defendant. Here, the only way we're doubting or casting doubt upon Kimberly's testimony is the specter of the criminal action to be brought. Again, Brittany had passed away more than a year prior to the deposition that Kimberly submitted to. So for that reason, I believe that the lower court should be reversed as well, and will adopt the arguments of co-counsel. Thank you, Your Honors.
Thank you. And one more.
I can be fast too.
Good.
Briefly, again, no evidence as to who was driving. They've both touched on it. And if you don't know who's driving, there's no one for Kimberly Hunter to give permission to. Non-permissive use, no coverage. And there's a lot of speculation about Brittany driving, but it's just speculation. I wanted to ask this court, and it's a rhetorical question really, but what's the authority that the court can say there's a question on credibility when there's no contradictory testimony? We don't have that citation. We don't have that law. We have the unrefuted testimony of Kimberly Hunter. Regarding the non-cooperation and co-burn issue that Sister Counsel brought up, I just want to point out for the court, that is raised for the first time in this court on this appeal. That was not raised at all in the trial court. And I think that's worth noting, because if it's not raised in the trial court, I don't think it's properly before the court here. But
I think it's right though, isn't it?
I am not going to say that it's right or wrong, because I did not look at that issue as closely as I wanted to. But
It's a third-party claim.
It is a third-party claim, but I just wanted to point that out as well. And regarding Brittany's residence, I think there is a question here. Well, I'm just gonna just leave it at that. I'm done. Thank you very much.
Okay, thank you very much. Well argued by everyone. We appreciate it. It's a good way to end.
Tell Mr. Granzada we missed him today.